Rule 34. Production of documents, electronically stored information, and things and entry upon land for inspection and other purposes. A scope. Any party may serve on any other party a request. 1. To produce and permit the party making the request, or someone acting on the requester's behalf, to inspect and copy any designated documents or electronically stored information, including, without limitation, writings, drawings, graphs, charts, photographs, sound recordings, images and other data or data compilations from which information can be obtained or translated, if necessary, by the respondent into reasonably usable form, or to inspect and copy, test, or sample any designated tangible things which constitute or contain matters within the scope of Rule 26b and which are in the possession, custody or control of the party upon whom the request is served, or 2. To permit entry upon designated land or other property in the possession or control of the party upon whom the request is served for the purpose of inspection and measuring, surveying, photographing, testing, or sampling the property or any designated object or operation thereon, within the scope of Rule 26b. B. Procedure. The request may, without leave of court, be served upon the plaintiff after commencement of the action and upon any other party with or after service of the summons and complaint upon that party. The request shall set forth the items to be inspected either by individual item or by category, and describe each item and category with reasonable particularity. The request may specify the form or forms in which electronically stored information is to be produced. The request shall specify a reasonable time, place, and manner of making the inspection and performing the related acts. Service is dispensed with if the whereabouts of the parties is unknown. The party upon whom the request is served shall serve a written response within a period designated in the request, not less than 30 days after the service thereof or within such shorter or longer time as the court may allow. The response shall state, with respect to each item or category, that inspection and related activities will be permitted as requested, unless it is objected to, including an objection to the requested form or forms for producing electronically stored information, stating in which event the reasons for objection shall be stated. If objection is made to part of an item or category, the part shall be specified. If objection is made to the requested form or forms for producing electronically stored information, or if no form was specified in the request, the responding party must state the form or forms it intends to use. The party submitting the request may move for an order under Rule 37a with respect to any objection to or other failure to respond to the request or any part thereof, or any failure to permit inspection as requested. Unless the parties otherwise agree, or the court otherwise orders, a party who produces documents for inspection shall produce them as they are kept in the usual course of business, or shall organize and label them to correspond with the categories and he request. If a request for electronically stored information does not specify the form or forms of production, a responding party must produce the information in a form or forms in which it is ordinarily maintained or in a form or forms that are reasonably usable. A party need not produce the same electronically stored information in more than one form. C. Application to non-parties. 1. A witness or person other than a party may be requested to produce or permit the matters allowed by subsection A of his rule. Such request shall be served upon other parties and included in or with the subpoena served upon such witness or person. 2. Neither a request nor subpoena to produce or permit as permitted by this rule shall be served upon a non-party until at least 15 days after the date on which the party intending to serve such request or subpoena serves a copy of the proposed request and subpoena on all other parties. Provided, however, that if such request or subpoena relates to a matter set for hearing within such 15-day period or arises out of a bona fide emergency, such request or subpoena may be served upon a non-party one day after receipt of the proposed request or subpoena by all other parties. 3. The request shall contain the matter provided in subsection B of this rule. It shall also state that the witness or person to whom it is directed is entitled to security against damages or payment of damages resulting from such request and may respond to such request by submitting to its terms, by proposing different terms, by objecting specifically or generally to the request, by serving a written response to the party making the request within 30 days, or by moving to quash as permitted by Rule 45b. Any party, or any witness or person upon whom the request properly is made may respond to the request as provided in subsection B of this rule. If the response of the witness or person to whom it is directed is unfavorable, if he moves to quash, if he refuses to cooperate after responding or fails to respond, or if he objects, the party making the request may move for an order under Rule 37a with respect to any such response or objection. In granting an order under this subsection and Rule 37a(2), the court shall condition relief upon the prepayment of damages to be approximately incurred by the witness or person to whom the request is directed or require an adequate surety bond or other indemnity conditioned against such damages. Such damages shall include reasonable attorney's fees incurred in reasonable resistance and in establishing such threatened damage or damages. 4. A party receiving documents from a non-party pursuant to this provision shall serve copies on all other parties within 15 days of receiving the documents. If the documents are voluminous and service of a complete set of copies is burdensome, the receiving party shall notify all parties within 15 days of receiving the documents that the documents are available for inspection at the location of their production by the non-party, or at another location agreed to by the parties. The parties shall agree to arrangements for copying, and any party desiring copies shall bear the cost of reproducing them. D. Exception to best evidence rule. When a party or witness in control of a writing or document subject to examination under this rule or Rule 9. 2e refuses or is unable to produce it, evidence thereof shall be allowed by other parties without compliance with the rule of evidence requiring production of the original document or writing as best evidence. Rule 35. Physical and mental examination of persons. A order for examination. When the mental or physical condition, including the blood group, of a party, or of a person in the custody or under the legal control of a party, is in controversy, the court in which the action is pending may order the party to submit to a physical or mental examination by a suitably licensed or certified examiner, or to produce for examination the person in his custody or legal control. The order may be made only on motion for good cause shown and upon notice to the person to be examined and to all parties, and shall specify the time, place, manner, conditions, and scope of the examination and the person or persons by whom it is to be made. B. Report of licensed or certified examiner. 1. If requested by the party against whom an order is made under Rule 35a or the person examined, the party causing the examination to be made shall deliver to him a copy of a detailed written report of the examiner setting out his findings, including results of all tests made, diagnoses and conclusions, together with like reports of all earlier examinations of the same condition. After delivery, the party causing the examination shall be entitled upon request to receive from the party against whom the order is made a like report of any examination, previously or thereafter made, of the same condition, unless, in the case of a report of examination of a person not a party, the party shows that he is unable to obtain it. The court on motion may make an order against a party requiring delivery of a report on such terms as are just, and if an examiner fails or refuses to make a report, the court may exclude his testimony if offered at the trial. 2. By requesting and obtaining a report of the examination so ordered or by taking the deposition of the examiner, the party examined waives any privilege he may have in that action or any other involving the same controversy. Regarding the testimony of every other person who has examined or may thereafter examine him in respect of the same mental or physical condition. 3. This subdivision applies to examinations made by agreement of the parties, unless the agreement expressly provides otherwise. This subdivision does not preclude discovery of a report of an examiner or the taking of a deposition of the examiner in accordance with the provisions of any other rule. Rule 36. Requests for admission. A request for admission. A party may serve upon any other party a written request for the admission, for purposes of the pending action only, of the truth of any matters within the scope of Rule 26b set forth in the request, including the genuineness of any documents described in the request. Copies of documents shall be served with the request unless they have been or otherwise furnished or made available for inspection and copying. The request may, without leave of court, be served upon the plaintiff after commencement of the action and upon any other part with or after service of the summons and complaint upon that party. Each matter of which an admission is requested shall be separately set forth. The matter is admitted unless, within a period designated in the request, not less than 30 days after service thereof or within such shorter or longer time as the court may allow. The party to whom the request is directed serves upon the party requesting the admission a written answer or objection addressed to the matter, signed by the party or by his attorney. If objection is made, the reasons therefor shall be stated. The answer shall specifically deny the matter or set forth in detail the reasons why the answering party cannot truthfully admit or deny the matter. A denial shall fairly meet the substance of the requested admission, and when good faith requires that a party qualify his answer or deny only a part of the matter of which an admission is requested, he shall specify so much of it as is true and qualify or deny the remainder. An answering party may not give lack of information or knowledge as a reason for failure to admit or deny unless he states that he has made reasonable inquiry and that the information known or readily obtainable by him is insufficient to enable him to admit or deny, or that the inquiry would be unreasonably burdensome. A party who considers that a matter of which an admission has been requested presents a genuine issue for trial may not, on that ground alone, object to the request. He may, subject to the provisions of Rule 37c, deny the matter or set forth reasons why he cannot admit or deny it. The party who has requested the admissions may move for an order with respect to the answers or objections. Unless the court determines that an objection is justified, it shall order that an answer be served. If the court determines that an answer does not comply with the requirements of this rule, it may order either that the matter is admitted or that an amended answer be served. The court may, in lieu of these orders, determine that final disposition of the request be made at a pre-trial conference or at a designated time prior to trial. The provisions of Rule 37(a)(4) apply to the award of expenses incurred in relation to the motion. B. Effect of admission. Any matter admitted under this rule is conclusively established unless the court on motion permits withdrawal or amendment of the admission. Subject to the provisions of Rule 16 governing amendment of a pre-trial order. The court may permit withdrawal or amendment when the presentation of the merits of the action will be subserved thereby and the party who obtained the admission fails to satisfy the court that withdrawal or amendment will prejudice him in maintaining his action or defense on the merits. Any admission made by a party under this rule is for the purpose of the pending action only and is not an admission by him for any other purpose, nor may it be used against him in any other proceeding. Rule 37. Failure to make or cooperate in discovery, sanctions. A motion for order compelling discovery. A party, upon reasonable notice to other parties and all persons affected thereby, may apply for an order compelling discovery as follows. 1. Appropriate court. An application for an order to a party may be made to the court in which the action is pending, or alternately, on matters relating to a deposition or an order under Rule 34. To the court in the county where the deposition is being taken or where compliance is to be made under Rule 34. An application for an order to a deponent who is not a party shall be made to the court in the county where the deposition is being taken. 2. Motion. If a party refuses to allow inspection under Rule 9. 2e. Or if a deponent fails to answer a question propounded or submitted under Rule 30 or 31, or an organization, including without limitation a governmental organization or a partnership, fails to make designation under Rule 30(b)(6) or 31(a), or a party fails to answer an interrogatory submitted under Rule 33, or if a party or witness or other person, in response to a request submitted under Rule 34, fails to respond that inspection will be permitted as requested or fails to permit inspection as requested, the discovering party may move for an order compelling an answer, or a designation, or an order compelling inspection in accordance with the request. When taking a deposition on oral examination, the proponent of the question may complete or adjourn the examination before he applies for an order. If the court denies the motion in whole or in part, it may make such protective order as it would have been empowered to make on a motion made pursuant to Rule 26(c). 3. Evasive or incomplete answer. For purposes of this subdivision, an evasive or incomplete answer is to be treated as a failure to answer. 4. Award of expenses of motion. If the motion is granted, the court shall, after opportunity for hearing, require the party or deponent whose conduct necessitated the motion or the party or attorney advising such conduct or both of them to pay to the moving party the reasonable expenses incurred in obtaining the order, including attorney's fees, unless the court finds that the opposition to the motion was substantially justified or that other circumstances make an award of expenses unjust. If the motion is denied, the court shall, after opportunity for hearing, require the moving party or the attorney advising the motion or both of them to pay to the party or deponent who opposed the motion the reasonable expenses incurred in opposing the motion, including attorney's fees, unless the court finds that the making of the motion was substantially justified or that other circumstances make an award of expenses unjust. If the motion is granted in part and denied in part, the court may apportion the reasonable expenses incurred in relation to the motion among the parties and persons in a just manner. B. Failure to comply with order. 1. Sanctions by court in county where deposition is taken. If a deponent fails to be sworn or to answer a question after being directed to do so by the court in the county in which the deposition is being taken, the failure may be considered a contempt of that court. 2. Sanctions by court in which action is pending. If a party or an officer, director, or managing agent of a party or an organization, including a governmental organization, or a person designated under Rule 30(b)(6) or 31(a) to testify on behalf of a party or an organization, including a governmental organization, fails to obey an order to provide or permit discovery, including an order made under subdivision A of this rule or Rule 35. The court in which the action is pending may make such orders in regard to the failure as are just, and among others the following. An order that the matters regarding which the order was made or any other designated facts shall be taken to be established for the purposes of the action in accordance with the claim of the party obtaining the order. B. An order refusing to allow the disobedient party to support or oppose designated claims or defenses, or prohibiting him from introducing designated matters in evidence. C. An order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or proceeding or any part thereof, or rendering a judgment by default against the disobedient party. D. In lieu of any of the foregoing orders or in addition thereto, an order treating as a contempt of court the failure to obey any orders except in order to submit to a physical or mental examination under Rule 35. E. Where a party has failed to comply with an order under Rule 35(a) requiring him to produce another for examination, such orders as are listed in paragraphs A, B, and C of this subdivision, unless the part Y failing to comply shows that he is unable to produce such person for examination. In lieu of any of the foregoing orders or in addition thereto, the court shall require the party failing to obey the order or the attorney advising him or both to pay the reasonable expenses, including attorney's fees, caused by the failure, unless the court finds that the failure was substantially justified or that other circumstances make an award of expenses unjust. C. Expenses on failure to admit. If a party fails to admit the genuineness of any document or the truth of any matter as requested under Rule 36, and if the party requesting the admissions thereafter proves the genuineness of the document or the truth of the matter, he may apply to the court for an order requiring the other party to pay him the reasonable expenses incurred in making that proof, including reasonable attorney's fees. The court shall make the order unless it finds that 1. The request was held objectionable pursuant to Rule 36(a), or 2. The admission sought was of no substantial importance, or 3. The party failing to admit had reasonable ground to believe that he might prevail on the matter, or 4. There was other good reason for the failure to admit. D. Failure of party to attend at all deposition or serve answers to interrogatories or respond to requests for inspection. If a party or an officer, director, or managing agent of a party or an organization, including without limitation a governmental organization, or a person designated under Rule 30(b)(6) or 31(a) to testify on behalf of a party or an organization, including without limitation a governmental organization, fails 1. To appear before the officer who is to take his deposition, after being served with the proper notice, or 2. To serve the answers or objections to interrogatories submitted under Rule 33, after proper service of the interrogatories, or 3. To serve a written response to a request for inspection submitted under Rule 34. After proper service of the request, the court in which the action is pending on motion may make such orders in regard to the failure as are just, and among others it may take any action authorized under paragraphs A, B, and C of subdivision B2 of this rule. In lieu of any order or in addition thereto, the court shall require the party failing to act or the attorney advising him or both to pay the reasonable expenses, including attorney's fees, caused by the failure. Unless the court finds that the failure was substantially justified or that other circumstances make an award of expenses unjust. The failure to act described in this subdivision may not be excused on the ground that the discovery sought is objectionable unless the party failing to act has applied for a protective order as provided by Rule 26 C. E. Electronically stored information. Absent exceptional circumstances, a court may not impose sanctions under these rules on a party for failing to provide electronically stored information lost as a result of the routine, good faith operation of an electronic information system. Rule 38. Jury trial of right. A cause is triable by court and by jury. Issues of law and issues of fact and causes that prior to the 18th day of June, 1852, were of exclusive equitable jurisdiction shall be tried by the court. Issues of fact in all other causes shall be triable as the same are now triable. In case of the joinder of causes of action or defenses which, prior to said date, were of exclusive equitable jurisdiction with causes of action or defenses which, prior to said date, were designated as actions at law and triable by jury, the former shall be triable by the court, and the latter by a jury, unless waived. The trial of both may be at the same time or at different times, as the court may direct. B. Demand. Any party may demand a trial by jury of any issue triable of right by a jury by filing with the court and serving upon the other parties a demand therefor in writing at any time after the commencement of the action and not later than 10 days after the first responsive pleading to the complaint, or to a counterclaim, cross-claim or other claim if one properly is pleaded, and if no responsive pleading is filed or required, within 10 days after the time such pleading otherwise would have been required. Such demand is sufficient if endorsed upon a pleading of a party filed within such time. C. Same. Specification of issues. In his demand a party may specify the issues which he wishes so tried. Otherwise he shall be deemed to have demanded trial by jury for all issues triable as of right by jury. Any other party must file a demand for jury trial to preserve his right to trial by jury. 1. Of issues for which a right to trial by jury was not requested by another party, and 2. In case a request by another party was improper. But if a proper request for a trial by jury upon issues triable by jury as of right on his behalf is made by any party, such request shall be deemed to have been made on behalf of all parties entitled to a jury trial upon such issues. D. Waiver. The failure of a party to appear at the trial, and the failure of a party to serve a demand as required by this rule and to file it as required by Rule 5(e) constitute waiver by him of trial by jury. A demand for trial by jury made as herein provided may not be withdrawn without the consent of the other party or parties. The trial court shall not grant a demand for a trial by jury filed after the time fixed in trial. 38(b) has elapsed except upon the written agreement of all of the parties to the action, which agreement shall be filed with the court and made a part of the record. If such agreement is filed, then the court may, in its discretion, grant a trial by jury, in which event the grant of a trial by jury may not be withdrawn except by the agreement of all of the parties. Arbitration. Nothing in these rules shall deny the parties the right by contract or agreement to submit or to agree to submit controversies to arbitration made before or after commencement of an action thereon, or deny the court's power to specifically enforce such agreements. Rule 39. Trial by jury or by the court. A. By jury. When trial by jury has been demanded as provided in Rule 38, the action shall be designated in the chronological case summary as a jury action. Issues upon which a jury trial is so demanded shall be tried by jury, subject to the following exceptions. 1. If the parties or their attorneys of record, by written stipulation filed with the court or by oral stipulation made in open court and entered in the record, consent to trial by the court sitting without a jury upon any or all issues triable by jury as of right and so demanded, the court shall try those issues without a jury. The stipulation shall be effective only if filed or made in court before evidence is admitted at the trial or at such later time as the court, in its discretion, may allow. 2. If a party demands a jury trial on any issue upon which he is entitled to jury trial as of right in the case, the court shall grant it on that issue. B. By the court advisory jury trial by consent. In any case where there are issues upon which a jury trial has not been demanded or has not properly been demanded, or upon which there is no right to trial by jury as of right, the court may submit any or all of such issues to a jury for trial. The verdict shall be advisory unless, before the jury retires, the court, with the consent of both parties or their attorneys, orders that the verdict shall have the same effect as if a trial by jury had been a matter of right. Such order shall be granted at the court's discretion, and all issues shall be tried as if subject to jury trial as a matter of right unless the parties' consent is limited to fewer issues, or unless the court limits its order to fewer of those issues upon which consent has been given. C. Rulings of the court. Objections. In proceeding under Rules 38 and 39, error may be predicated upon the court's ruling or action without motion or other objection by a party. D. Findings in case of advisory jury. Findings of fact shall not be required upon issues to the extent that the judge's decision follows the verdict of a properly selected advisory jury. Rule 40. Assignment of cases for trial. AFN1. Rules for assignment of cases. The trial courts shall provide by rule for placing of actions upon the trial calendar. 1. Without request of the parties, or 2. Upon request of a party and notice to the other parties, or 3. In such manner as the court determines will expedite trials. Precedents shall be given to actions entitled thereto by any statute of the state, including hearings upon temporary restraining orders, injunctions and receiverships. FN1. This rule contains no subbed. B. Rule 41. Dismissal of actions. A voluntary dismissal, effect thereof. 1. By plaintiff by stipulation. Subject to contrary provisions of these rules or of any statute, an action may be dismissed by the plaintiff without order of court. By filing a notice of dismissal at any time before service by the adverse party of an answer or of a motion for summary judgment, whichever first occurs, or B. By filing a stipulation of dismissal signed by all parties who have appeared in the action. Unless otherwise stated in the notice of dismissal or stipulation, the dismissal is without prejudice. except that a notice of dismissal operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in any court of the United States or of any state an action based on or including the same claim. The provisions of this subdivision shall not apply if the plaintiff in such action could not effectuate service of process or otherwise procure adjudication on the merits. 2. By order of court. Except as provided in subsection 1 of this subdivision of this rule, an action shall not be dismissed at the plaintiff's instance save upon order of the court and upon such terms and conditions as the court deems proper. If a counterclaim or cross-claim has been pleaded by a defendant prior to the service upon him of the plaintiff's motion to dismiss, the action shall not be dismissed against the defendant's objection unless the counterclaim or cross-claim can remain pending for independent adjudication by the court. Unless otherwise specified in the order, a dismissal under this subsection is without prejudice. B. Involuntary dismissal, effect thereof. After the plaintiff or party with the burden of proof upon an issue, in an action tried by the court without a jury, has completed the presentation of his evidence thereon, the opposing party, without waiving his right to offer evidence in the event the motion is not granted, may move for a dismissal on the ground that upon the weight of the evidence and the law there has been shown no right to relief. The court as trier of facts may then determine them and render judgment against the plaintiff, or may decline to render any judgment until the close of all the evidence. If the court renders judgment on the merits against the plaintiff or party with the burden of proof, the court, when requested at the time of the motion by either party, shall make findings if, and as required by Rule 52a. Unless the court at its order for dismissal, provided for in this rule, other than a dismissal for lack of jurisdiction, operates as an adjudication upon the merits. C. Dismissal of counterclaim, cross-claim, or third-party claim. The provisions of this rule apply to the dismissal of any counterclaim, cross-claim, or third-party claim. A voluntary dismissal by the claimant alone pursuant to subsection 1 of subdivision A of this rule shall be made before a responsive pleading is served or, if there is none, before the introduction of evidence at the trial or hearing. D. Costs of previously dismissed action. If a plaintiff who has once dismissed an action in any court commences an action based upon or including the same claim against the same defendant, the court may make such order for the payment of costs of the action previously dismissed as it may deem proper, and may stay the proceedings in the action until the plaintiff has complied with the order. E. Failure to prosecute civil actions or comply with rules. Whenever there has been a failure to comply with these rules, or when no action has been taken in a civil case for a period of 60 days, the court, on motion of a party or on its own motion, shall order a hearing for the purpose of dismissing such case. The court shall enter an order of dismissal at plaintiff's costs if the plaintiff shall not show sufficient cause at or before such hearing. Dismissal may be withheld or reinstatement of dismissal may be made subject to the condition that the plaintiff comply with these rules and diligently prosecute the action, and upon such terms that the court at its discretion determines to be necessary to assure such diligent prosecution. F. Reinstatement following dismissal. For good cause shown and within a reasonable time, the court may set aside a dismissal without prejudice. A dismissal with prejudice may be set aside by the court for the grounds and in accordance with the provisions of Rule 60b. Rule 42. Consolidation. Separate trials. A consolidation. When actions involving a common question of law or fact are pending before the court, it may order a joint hearing or trial of any or all the matters in issue in the actions, It may order all the actions consolidated, and it may make such orders concerning proceedings therein as may tend to avoid unnecessary costs or delay. B. Separate trials. The court, in furtherance of convenience or to avoid prejudice, or when separate trials will be conducive to expedition and economy, may order a separate trial of any claim, cross-claim, counterclaim, or third-party claim, or of any separate issue or of any number of claims, cross-claims, counterclaims, third-party claims, or issues, always preserving inviolate the right of trial by jury. C. Submission to jury in stages. The court upon its OWN motion or the motion of any party for good cause shown may allow the case to be tried and submitted to the jury in stages or segments including, but not limited to, bifurcation of claims or issues of compensatory and punitive damages. D. Actions pending in different courts. When civil actions involving a common question of law or fact are pending in different courts, a party to any of the actions may, by motion, request consolidation of those actions for the purpose of discovery and any pre-trial proceedings. Such motion may only be filed in the court having jurisdiction of the action with the earliest filing date, and the court shall enter an order of consolidation for the purpose of discovery and any pre-trial proceedings unless good cause to the contrary is shown and found by the court to exist. In the event two or more actions have the same earliest filing date, the motion may be filed only in the court having the lowest court identifier number under Administrative Rule 8b(1), which court shall be considered as having the action with the earliest filing date. Upon completion of discovery and any pre-trial proceedings, each case which has been subject to the order of consolidation shall be ordered returned to the court in which it was pending at the time the order of consolidation was made, unless, after notice to all parties and a hearing, the court finds that the action involves unusual or complicated issues of fact or law, or involves a substantial question of law of great public importance. In the event the court makes such a finding, it may enter an order of consolidation for the purpose of trial, except for cause pursuant to Act 34-35-1-1. The right to change of venue in any action consolidated under this rule shall be suspended during the period of consolidation. Such right shall be reinstated on entry of an order remanding the action to the court in which it was pending at the time of consolidation, and the time prescribed for the filing of a motion for change of venue shall be deemed told during the period of suspension. Nothing in this rule shall restrict the equitable discretion of the court having the earliest filed action to dismiss or stay that action. If such an order is entered, that court shall no longer be considered the court in which is pending the action with the earliest filing date for purposes of this rule. This subsection D shall not apply to actions pending in courts of limited jurisdiction, and no such action may be consolidated with another under the provisions of this subsection D. Rule 43. Evidence. A. Form and admissibility. In all trials the testimony of witnesses shall be taken in open court, unless state law, these rules, the Indiana Rules of Evidence, or other rules adopted by the Indiana Supreme Court provide otherwise. B. Evidence on motions. When a motion is based on facts not appearing of record, the court may hear the matter on affidavits presented by the respective parties, but the court may direct that the matter be heard wholly or partly on oral testimony or depositions. C. Interpreters. The court may appoint an interpreter of its own selection and may fix his reasonable compensation. The compensation shall be paid out of funds provided by law or by one or more of the parties as the court may direct, and may be taxed ultimately as costs, in the discretion of the court. Application of this rule shall be in compliance with the Americans with Disabilities Act. D. How evidence is presented. The trial shall proceed in the following order, unless the court within its discretion otherwise directs. First, the party upon whom rests the burden of the issues may briefly state his case and the evidence by which he expects to sustain it. Second, the adverse party may then briefly state his defense and the evidence he expects to offer in support of it. Third, the party on whom rests the burden of the issues must first produce his evidence thereon. The adverse party will then produce his evidence, which may then be rebutted. E. Public access. Court records filed or introduced in court proceedings are not confidential except to the extent provided by the rules on access to court records. Rule 44. Proof of official record. The rules concerning proof of official records are governed by the rules of evidence. Rule 44.1. Determination of foreign law. A foreign law. A party who intends to raise an issue concerning the law of a foreign country shall give notice in his pleadings or other reasonable written notice. The court, in determining foreign law, may consider any relevant material or source, including testimony, whether or not submitted by a party or admissible under Rule 43. The court's determination shall be treated as a ruling on a question of law. It shall be made by the court and not the jury and shall be reviewable. B. Law of other states and territories. Judicial notice, proof and notice of intent to offer evidence of the law of another jurisdiction not covered by subdivision A of this rule shall be governed by the Uniform Judicial Notice of Foreign Law Act, 1937 Indiana Acts, ch. 124, FN1. FN1, IC 34-3-2-1 to 34-3-2-7, repealed in 1998. Rule 45. Subpoena. A. For attendance of witnesses form issuance. 1. Every subpoena shall a. State the name of the court. B. State the title of the action without naming more than the first named plaintiffs and defendants in the complaint and the case number. And C. Command each person to whom it is directed to attend and give testimony at a time and place therein specified. 2. The clerk shall issue a subpoena, or a subpoena for the production of documentary evidence, signed and sealed but otherwise in blank, to a party requesting it or his or her attorney, who shall fill it in before service. An attorney admitted to practice law in the state, as an officer of the court, may also issue an such subpoena on behalf of a court in which the attorney has appeared for a party, or b. a court in which a deposition or production is compelled by the subpoena, if the deposition or production pertains to an action pending in a court where the attorney has appeared for a party in that case. B. For production of documentary evidence. A subpoena may also command the person to whom it is directed to produce the books, papers, documents, or tangible things designated therein, but the court, upon motion made promptly and in any event at or before the time specified in the subpoena for compliance therewith, may 1. Quash or modify the subpoena if it is unreasonable and oppressive, or 2. Condition denial of the motion upon the advancement by the person in whose behalf the subpoena is issued of the reasonable cost of producing the books, papers, documents, or tangible things. C. Service. A subpoena may be served by the sheriff or his deputy, a party or any person. Service of a subpoena upon a person named therein shall be made by delivering a copy thereof to such person. Service may be made in the same manner as provided in Rule 4.1, Rule 4.16 and Rule 5b. D. Subpoena for taking depositions. Place of examination. 1. Proof of service of a notice to take a deposition as provided in Rules 30b and 31a constitutes a sufficient authorization for the issuance by the clerk of court for the county in which the deposition is to be taken of subpoenas for the persons named or described therein. The subpoena may command the person to whom it is directed to produce designated books, papers, documents, or tangible things which constitute or contain matters within the scope of the examination permitted by Rule 26b. But in that event the subpoena will be subject to the provisions of Rule 26c and Subdivision b of this rule. 2. An individual may be required to attend an examination only in a county wherein he resides or is employed or transacts his business in person, or at such other convenient place as is fixed by an order of court. A non-resident of the state may be required to attend only in the state and county wherein he is served with a subpoena, or within 40 miles from the place of service, or at such other convenient place as is fixed by an order of court. A non-resident plaintiff may be required to attend at his own expense an examination in the county of the state where the action is commenced or in a county fixed by the court. E. Subpoena for a hearing or trial. At the request of any part, subpoenas for attendance at a hearing or trial shall be issued by the clerk of court of the county in which the action is pending when requested, or, in the case of a subpoena for the taking of a deposition, by the clerk of court of the county in which the action is so pending, or in the county in which the deposition is being taken. An attorney admitted to practice law in the state, as an officer of the court, may also issue and sign such subpoenas on behalf of the court in which the action is pending or a court of the county in which the deposition is being taken. If the hearing, deposition or production pertains to an action pending in a court where the attorney has appeared for a party in that case, a subpoena may be served at any place within the state, and when permitted by the laws of the United States, this or another state or foreign country, the court upon proper application and cause shown may authorize the service of a subpoena outside the state in accordance with and as permitted by such law. F. Contempt. Failure by any person without adequate excuse to obey a subpoena served upon him may be deemed a contempt of the court from which the subpoena issued, or court of the county where the witness was required thereafter to appear or act. The attendance of all witnesses when duly subpoenaed, and to whom fees have been paid or tendered as required by law, may be enforced by attachment. G. Tender of fees. Service of a subpoena upon a person named therein shall be made by delivering a copy thereof to such person who shall be required to attend outside his county of residence as provided in Section C, and by so tendering to him the fees for 1 day's attendance and the mileage allowed by law. Such tender shall not be required to be made to a party who is subpoenaed or to an officer, employee, agent or representative of a party which is an organization, including the estate or any governmental organization, who is being examined upon any matter connected in any way with his employment or with duties to the organization. H. Proof of service of subpoena fees. When a subpoena is served by the sheriff or his deputy, his return shall be proof of service. When served by any other person, the service must be shown by affidavit. No fees or costs for the service of a subpoena shall be collected or charged as costs except when service is made by the sheriff or his deputy. Rule 46. Exceptions unnecessary. Formal exceptions to rulings or orders of the court are unnecessary, but for all purposes for which an exception has heretofore been necessary, it is sufficient that a party, at the time the ruling or order of the court is made or sought, makes known to the court the action which he desires the court to take or his objection to the action of the court and his grounds therefor, and, if a party has no opportunity to object to a ruling or order at the time it is made, the absence of an objection does not thereafter prejudice him. Rule 47. Jurors and peremptory challenges. A number of jurors in civil cases. In all civil cases, the jury shall consist of six members. B. Alternate jurors. The court may direct that no more than three jurors in addition to the regular jury be called and impaneled to sit as alternate jurors. Alternate jurors in the order in which they are called shall replace jurors who, prior to the time the jury returns its verdict, become or are found to be unable or disqualified to perform their duties. Alternate jurors shall be drawn in the same manner, shall have the same qualifications, shall be subject to the same examination and challenges, shall take the same oath, and shall have the same functions, powers, facilities and privileges as the regular jurors. An alternate juror who does not replace a regular juror shall be discharged after the jury brings in its verdict. If alternate jurors are permitted to attend deliberations, they shall be instructed not to participate. C. Peremptory challenges. 1. Each side shall have three peremptory challenges. 2. In addition to the peremptory challenges under subsection 1, each side is entitled to a 1 peremptory challenge if the court directs that one or two alternate jurors are to be impaneled, or b. 2 peremptory challenges if the court directs that three alternate jurors are to be impaneled. 3. The additional peremptory challenges under subsection 2 may be used only against alternate jurors, and the peremptory challenges under subsection 1 may not be used against alternate jurors. D. Examination of jurors. The court shall permit the parties or their attorneys to conduct the examination of prospective jurors, and may conduct examination itself. The court's examination may include questions, if any, submitted in writing by any party or attorney. If the court conducts the examination, it shall permit the parties or their attorneys to supplement the examination by further inquiry. The court may impose an advance time limitation upon such examination by the parties or their attorneys. At the expiration of said limitation, the court shall liberally grant additional reasonable time upon a showing of good cause related to the nature of the case, the quantity of prospective jurors examined and juror vacancies remaining, and the manner and content of the inquiries and responses given by the prospective jurors. The court may prohibit the parties and their attorneys from examination which is repetitive, argumentative, or otherwise improper, but shall permit reasonable inquiry of the panel and individual prospective jurors. Rule 48. Juries of less than 6 majority verdict. The parties may stipulate that the jury shall consist of any number less than six at any time before the jury is selected, or that a verdict or a finding of a stated majority of the jurors shall be taken as the verdict or finding of the jury at any time before the verdict has been announced. Rule 49. Special verdicts and interrogatories. Special verdicts and interrogatories to the jury are abolished. Rule 50. Judgment on the evidence, directed verdict. A judgment on the evidence how raised effect. Where all or some of the issues in a case tried before a jury or an advisory jury are not supported by sufficient evidence, or verdict thereon is clearly erroneous as contrary to the evidence because the evidence is insufficient to support it. the court shall withdraw such issues from the jury and enter judgment thereon, or shall enter judgment thereon notwithstanding a verdict. A party may move for such judgment on the evidence. 1. After another party carrying the burden of proof or of going forward with the evidence upon any one or more issues has completed presentation of his evidence thereon, or 2. After all the parties have completed presentation of the evidence upon any one or more issues, or 3. After the evidence in the case has been presented and before judgment, or 4. In a motion to correct errors, or 5. May raise the issue upon appeal for the first time in criminal appeals, but not in civil cases, or 6. The trial court upon its own motion may enter such a judgment on the evidence at any time before final judgment, or before the filing of a notice of appeal, or, if a motion to correct error is made, at any time before entering its order or ruling thereon. A party who moves for judgment on the evidence at the close of the evidence offered by an opponent may offer evidence in the event that the motion is not granted, without having reserved the right so to do and to the same extent as if the motion had not been made. A motion for a judgment on the evidence which is not granted or which is granted only as to a part of the issues is not a waiver of trial by jury even though all parties to the action have moved for judgment on the evidence. A motion for judgment on the evidence made at one stage of the proceedings is not a waiver of the right of the court or of any party to make such motion on the same or different issues or reasons at a later stage as permitted above, except that error of the court in denying the motion shall be deemed corrected by evidence thereafter offered or admitted. B. Jury trial subject to entry of judgment on the evidence. Every case tried by a jury is made subject to the right of the court, before or after the jury is discharged, to enter final judgment on the evidence, without directing a verdict thereon. C. New trial in lieu of judgment on the evidence. When a judgment on the evidence is sought before or after the jury is discharged, the court may grant a new trial as to part or all of the issues in lieu of a judgment on the evidence when entry of a judgment is impracticable or unfair to any of the parties or otherwise is improper, whether requested or not. D. Reasons for judgment on the evidence. Partial relief. A motion or request for a judgment on the evidence shall state the reasons therefor, but it need not be accompanied by a peremptory instruction or prayer for particular relief. In appropriate cases the court, in whole or in part, may grant to some or all of the parties a judgment on the evidence or new trial in lieu thereof. Unless otherwise specified, a motion or request for a judgment on the evidence is general, but the court shall grant such judgment or relief only as is proper. E. Motion for judgment notwithstanding verdict, motion and arrest of judgment, demurrer to the evidence and venire de novo abolished. The motion for judgment notwithstanding verdict, motion and arrest of judgment, demurrer to the evidence, and venire de novo are abolished. Rule 51. Instructions to jury, objections, requests, submission and stages. A. Preliminary instructions. When the jury has been sworn, the court shall instruct the jury in accordance with Jury Rule 20. Each party shall have reasonable opportunity to examine these preliminary instructions and state his specific objections thereto out of the presence of the jury and before any party has stated his case. The court may of its own motion and, if requested by either party, shall reread to the jury all or any part of such preliminary instructions along with the other instructions given to the jury at the close of the case. A request to reread any preliminary instruction does not count against the 10 instructions provided in subsection D below. The parties shall be given reasonable opportunity to submit requested instructions prior to the swearing of the jury, and object to instructions requested or proposed to be given. B. Final instructions. The judge shall instruct the jury as to the law upon the issues presented by the evidence in accordance with Jury Rule 26. C. Objections and requested instructions before submission. At the close of the evidence and before argument, each party may file written requests that the court instruct the jury on the law as set forth in the requests. The court shall inform counsel of its proposed action upon the requests prior to their arguments to the jury. No party may claim as error the giving of an instruction unless he objects thereto before the jury retires to consider its verdict, stating distinctly the matter to which he objects and the grounds of his objection. Opportunity shall be given to make the objection out of the hearing of the jury. The court shall note all instructions given, refused or tendered, and all written objections submitted thereto shall be filed in open court and become a part of the record. Objections made orally shall be taken by the reporter and thereby shall become a part of the record. D. Limit upon requested instructions. Each party shall be entitled to tender no more than 10 requested instructions, including pattern instructions, to be given to the jury. However, the court at its discretion for good cause shown may fix a greater number. Each tendered instruction shall be confined to one relevant legal principle. No party shall be entitled to predicate error upon the refusal of a trial court to give any tendered instruction in excess of the number fixed by this rule or the number fixed by the court order, whichever is greater. E. Indiana Pattern Jury Instructions, Criminal/Indiana Model Jury Instructions, Civil. Any party requesting the trial court to give any instruction from the Indiana Pattern Jury Instructions, Criminal/Indiana Model Jury Instructions, Civil, prepared under the sponsorship of the Indiana Judges Association, may make such request in writing without copying the instruction verbatim, by merely designating the number thereof in the publication. Rule 52. Findings by the court. A. Effect. In the case of issues tried upon the facts without a jury or with an advisory jury, the court shall determine the facts and judgment shall be entered thereon pursuant to Rule 58. Upon its own motion, or the written request of any party filed with the court prior to the admission of evidence, the court in all actions tried upon the facts without a jury or with an advisory jury, except as provided in Rule 39d, shall find the facts specially and state its conclusions thereon. The court shall make special findings of fact without request. 1. In granting or refusing preliminary injunctions. 2. In any review of actions by an administrative agency, and 3. In any other case provided by these rules or by statute. On appeal of claims tried by the court without a jury or with an advisory jury, at law or in equity, the court on appeal shall not set aside the findings or judgment unless clearly erroneous, and due regard shall be given to the opportunity of the trial court to judge the credibility of the witnesses. The findings of a master, and answers to questions or interrogatories submitted to the jury shall be considered as findings of the court to the extent that the court adopts them. If an opinion or memorandum of decision is filed, it will be sufficient if the findings of fact and conclusions appear therein. Findings of fact are unnecessary on decisions of motions under Rules 12 or 56 or any other motion except as provided in Rule 41b, Dismissal, and 59j, Motion to correct errors. B. Amendment of findings and judgment causes therefore. upon its own motion at any time before a motion to correct errors, Rule 59, is required to be made, or with or as part of a motion to correct errors by any party, the court, in the case of a claim tried without a jury or with an advisory jury, may open the judgment, if one has been entered, take additional testimony, amend or make new findings of fact, and enter a new judgment or any combination thereof if 1. The judgment or findings are either against the weight of the evidence, or are not supported by or contrary to the evidence. 2. Special findings of fact required by this rule are lacking, incomplete, inadequate in form or content, or do not cover the issues raised by the pleadings or evidence. 3. Special findings of fact required by this rule are inconsistent with each other, or 4. The judgment is inconsistent with the special findings of fact required by this rule. Failure of a party to move to modify the findings or judgment under this subdivision and failure to object to proposed findings or judgment or such findings or judgment which has been entered of record shall not constitute a waiver of the right to raise the question in or with a motion to correct errors, or on appeal. C. Proposed findings. In any case where special findings of facts and conclusions thereon are to be made, the court shall allow and may require the attorneys of the parties to submit to the court a draft of findings of facts and conclusions thereon which they propose or suggest that the court make in such a case. D. Findings upon part of the issues. The court may make special findings of fact upon less than all the issues in a case when 1. Special findings of fact are made but are not required under this rule, or 2. Findings are required because of the request of a party or parties who have demanded findings only upon such specified issues. The court's failure to find upon a material issue upon which a finding of fact is required by this subdivision or this rule shall not be resolved by any presumption and may be challenged under subdivision B of this rule. But findings of fact with respect to issues upon which findings are not required shall be recognized as findings only upon the issues or matters covered thereby, and the judgment or general finding, if any, shall control as to the other issues or matters which are not covered by such findings. Rule 53. Masters. A. Appointment and compensation. Each trial court with the concurrence of the Supreme Court may appoint a special master in a case pending therein. As used in these rules, the word master includes without limitation an attorney, a referee, an auditor, an examiner, a commissioner, and an assessor. The compensation to be allowed to a master shall be allowed in the manner and amount paid to judges pro tem, and such additional compensation as is fixed by the Supreme Court. B. Reference. A reference to a master shall be the exception and not the rule. In actions to be tried by a jury, a reference shall be made only when the issues are complicated. In actions to be tried without a jury, save in matters of account and of difficult computation of damages, a reference shall be made only upon a showing that some exceptional condition requires it. Reference shall be allowed when the parties agree prior to trial as provided by these rules or by statute. C. Powers. The order of reference to the master may specify or limit his powers, and may direct him to report only upon particular issues, or to do or perform particular acts, or to receive and report evidence only, and may fix the time and place for beginning and closing the hearings, and for the filing of the master's report, subject to the specifications and limitations stated in the order. The master has and shall exercise the power to regulate all proceedings in every hearing before him, and to do all acts and take all measures necessary or proper for the efficient performance of his duties under the order. He may require the production before him of evidence upon all matters embraced in the reference, including the production of all books, papers, vouchers, documents, and order of reference, and has the authority to put witnesses on oath, and may himself examine them, and may call the parties to the action and examine them upon oath. When a party so requests, the master shall make a record of the evidence offered and excluded in the same manner and subject to the same limitations as provided in Rule 43 (c) for a court sitting without a jury. D. Proceedings 1 Meetings. When a reference is made, the clerk shall forthwith furnish the master with a copy of the order of reference. Upon receipt thereof, unless the order of reference otherwise provides, the master shall forthwith set a time and place for the first meeting of the parties or their attorneys, to be held within 20 days after the date of the order of reference, and shall notify the parties or their attorneys. It is the duty of the master to proceed with all reasonable diligence. Either party, on notice to the parties and master, may apply to the court for an order requiring the master to speed the proceedings and to make his report. If a party fails to appear at the time and place appointed, the master may proceed ex parte or, in his discretion, adjourn the proceedings to a future day, giving notice to the absent party of the adjournment. 2. Witnesses. The parties may procure the attendance of witnesses before the master by the issuance and service of subpoenas as provided in Rule 45. If without adequate excuse a witness fails to appear or give evidence, he may be punished as for a contempt and be subjected to the consequences, penalties, and remedies provided in Rules 37 and 45. 3. Statement of accounts. When matters of accounting are an issue before the master, he may prescribe the form in which the amounts shall be submitted, and in any proper case may require or receive in evidence a statement by a certified public accountant who is called as a witness. Upon objection of a party to any of the items thus submitted, or upon a showing that the form of statement is insufficient, the master may require a different form of statement to be furnished, or the accounts or specific items thereof to be provided by oral examination of the accounting parties, or upon written interrogatories or in such other manner as he directs. Report. 1. Contents and filing. The master shall prepare a report upon the matters submitted to him by the order of reference, and, if required by request of any party or the court prior to hearing or the taking of evidence by him, to make findings of fact, he shall set them forth in the report. He shall file the report with the clerk of the court, and in an action to be tried without a jury, unless otherwise directed by the order of reference, shall file with it a transcript of the proceedings and of the evidence and the original exhibits. The clerk shall forthwith mail to all parties notice of the filing. 2. In non-jury actions. In an action to be tried without a jury, the court shall accept the master's decision or his findings of fact unless clearly erroneous. Within 10 days after being served with notice of the filing of the report, any party may serve written objections thereto upon the other parties. Application to the court for action upon the report and upon objections thereto shall be by motion and upon notice as prescribed in Rules 5 and 6. The court after hearing may adopt the report or may reject it in whole or in part, or may receive further evidence or may recommit it with instructions. 3. In jury actions. In an action to be tried by a jury, the master shall not be directed to report the evidence. His findings upon the issues submitted to him are admissible as evidence of the matters found and may be read to the jury, subject to the ruling of the court upon any objections in point of law which may be made to the report. 4. Stipulation as to findings. The effect of a master's report is the same whether or not the parties have consented to the reference, but, when the parties stipulate that a master's findings of fact shall be final, only questions of law arising upon the report shall thereafter be considered. 5. Draft report. Before filing his report, a master may submit a draft thereof to counsel for all parties for the purpose of receiving their suggestions. F. Particular laws not affected. Nothing in this rule shall affect laws providing for the appointment and duties of probate commissioners, and nothing shall prevent any probate or other similar court from appointing a master under this rule. Rule 53.1. Failure to rule on motion. A timely mutation for ruling. In the event a court fails for 30 days to set a motion for hearing or fails to rule on a motion within 30 days after it was heard or 30 days after it was filed, if no hearing is required. Upon application by an interested party, the submission of the cause may be withdrawn from the trial judge and transferred to the Supreme Court for the appointment of a special judge. B. Exceptions. The timely mutation for ruling on a motion established under Section A of this rule shall exclude any period after which the case is referred to alternative dispute resolution and until a report on the alternative dispute resolution is submitted to the court. The timely mutation for ruling on a motion established under Section A of this rule shall not apply where 1. The court, within 30 days after filing, orders that a motion be considered during the trial on the merits of the cause, or 2. The parties who have appeared or their counsel stipulate or agree on record that the timely mutation for ruling on a motion shall not apply, or 3. The timely mutation for ruling has been extended by the Supreme Court as provided by Section D of this rule, or 4. The ruling in question involves a repetitive motion, a motion to reconsider, a motion to correct error, a petition for post-conviction relief, or a ministerial post-judgment act. C. Time of ruling. For the purposes of Section A of this rule, a court is deemed to have set a motion for hearing on the date the setting is noted in the chronological case summary, and to have ruled on the date the ruling is noted in the chronological case summary. D. Extension of time for ruling. A judge may apply to the Supreme Court of Indiana to extend the timely mutation set forth under Trial Rule 53.1, 53. 2, or 53.3. The application must be filed prior to the filing of a precipice with the clerk under Trial Rules 53.1, 53.2, or 53.3, must be verified, must be served on the clerk and all parties of record, and must set forth the following information. 1. The nature of the matter under submission. 2. The circumstances warranting the delay, and 3. The additional time requested. The withdrawal of submission under Trial Rule 53.1 or 53.2 or denial of a motion to correct error under Trial Rule 53.3 may not take effect during the pendency of the application for an extension of time to rule. However, if the timely mutation expires while the application is pending before the Supreme Court, the jurisdiction of the trial judge shall be suspended at that point pending the action of the Supreme Court. E. Procedure for withdrawing submission. Upon the filing by an interested party of a precipice specifically designating the motion or decision delayed, the clerk of the court shall enter the date and time of the filing on the precipice. record the filing in the chronological case summary under the clause, which entry shall also include the date and time of the filing of the precipice, and promptly forward the precipice and a copy of the chronological case summary to the Chief Administrative Officer (CAO) of the Indiana Office of Judicial Administration (IOJA). The CAO shall determine whether or not a ruling has been delayed beyond the time limitation set forth under Trial Rule 53.1 or 53.2. 1. If the CAO determines that the ruling or decision has not been delayed, the CAO shall provide notice of the determination in writing to the clerk of the court where the case is pending, and the submission of the cause shall not be withdrawn. The clerk of the court where the case is pending shall notify, in writing, the judge and all parties of record in the proceeding, and record the determination and the chronological case summary under the clause. 2. If the CAO determines that a ruling or decision has been delayed beyond the time limitation set forth under Trial Rule 53.1 or 53. 2. The CAO shall give written notice of the determination to the judge, the clerk of the trial court, and the clerk of the Supreme Court of Indiana that the submission of the case has been withdrawn from the judge. The withdrawal is effective as of the time of the filing of the precipice. The clerk of the trial court shall record this determination and the chronological case summary under the cause and provide notice to all parties in the case. The CAO shall submit the case to the Supreme Court of Indiana for appointment of a special judge or such other action deemed appropriate by the Supreme Court. F. Report to Supreme Court. When a special judge is appointed under Trial Rule 53.1 or 53. 2. The judge from whom submission was withdrawn shall, within 10 days from receipt of the order appointing a special judge, file a written report in the Supreme Court under the cause appointing the special judge. This report shall fully state the nature of the matters held in excess of the time limitations. Additionally, the report may relate any other facts or circumstances which the judge deems pertinent. G. Permanent record. The Supreme Court shall maintain a permanent record of special judge appointments under Trial Rules 53.1 and 53.2. Rule 53.2. Time for holding issue under advisement. Delay of entering a judgment. A time limitation for holding matter under advisement. Whenever a cause, including for this purpose a petition for post-conviction relief, has been tried to the court and taken under advisement by the judge, and the judge fails to determine any issue of law or fact within 90 days, the submission of all the pending issues in the cause may be withdrawn from the trial judge and transferred to the Supreme Court for the appointment of a special judge. B. Exceptions. The time limitation for holding an issue under advisement established under Section A of this rule shall not apply where 1. The parties who have appeared or their counsel stipulate or agree on record that the time limitation for decision set forth in this rule shall not apply, or 2. The time limitation for decision has been extended by the Supreme Court pursuant to Trial RL 53.1 d. C. Time of decision. For the purpose of Section A of this rule, a court is deemed to have decided on the date the decision is noted in the chronological case summary. D. Extension of time for decision. The procedure for extending the time limitation for decision shall be as set forth in Trial Rule 53.1 d. E. Procedure for withdrawing submission. The procedure for withdrawing submission and processing the appointment of a special judge shall be as set forth in Trial Rule 53.1 e. F. Report to Supreme Court. Whenever a special judge is appointed pursuant to this rule, the judge from whom submission has been withdrawn shall file a report with the Supreme Court as provided for in Trial Rule 53.1 f. Rule 53.3. Motion to correct error. Timely mutation for ruling. A timely mutation for ruling on motion to correct error. In the event a court fails for 45 days to set a motion to correct error for hearing, or fails to rule on a motion to correct error within 30 days after it was heard, or 45 days after it was filed. If no hearing is required, the pending motion to correct error shall be deemed denied. Any appeal shall be initiated by filing the Notice of Appeal under Appellate Rule 9A within 30 days after the motion to correct error is deemed denied. B. Exceptions. The timely mutation for ruling on a motion to correct error established under Section A of this rule shall not apply where 1. The party has failed to serve the judge personally, or 2. The parties who have appeared or their counsel stipulate or agree on record that the timely mutation for ruling set forth under Section A shall not apply, or 3. The timely mutation for ruling has been extended by Section D of this rule. C. Time of ruling. For the purposes of Section A of this rule, a court is deemed to have set a motion for hearing on the date the setting is noted in the chronological case summary, and to have ruled on the date the ruling is noted in the chronological case summary. D. Extension of time for ruling. The judge before whom a motion to correct error is pending may extend the timely mutation for ruling for a period of no more than 30 days by filing an entry in the cause advising all parties of the extension. Such entry must be in writing, must be noted in the chronological case summary before the expiration of the initial time period for ruling set forth under Section A, and must be served on all parties. Additional extension of time may be granted only upon application to the Supreme Court as set forth in Trial Rule 53.1d. Rule 53.4. Repetitive motions and motions to reconsider. Time for holding under advisement. Automatic denia. L. A. Repetitive motions and motions to reconsider ruling on a motion. No hearing shall be required upon a repetitive motion or upon motions to reconsider orders or rulings upon a motion. Such a motion by any party or the court or such action to reconsider by the court shall not delay the trial or any proceedings in the case, or extend time for any further required or permitted action, motion, or proceedings under these rules. B. Effect of court's delay in ruling upon repetitive motion or motion to reconsider ruling on a motion. Unless such a motion is ruled upon within 5 days it shall be deemed denied. An entry of service of notice of such denial shall not be required. This Rule 53.4 does not apply to an original motion for judgment on the evidence under Rule 50 if the jury is discharged, to amend or make additional findings of fact under Rule 60 or to the original motions to the extent expressly permitted or expressly designated as extending time under these rules. Rule 53.5. Continuances. Upon motion, trial may be postponed or continued in the discretion of the court, and shall be allowed upon a showing of good cause established by affidavit or other evidence. The court may award such costs as will reimburse the other parties for their actual expenses incurred from the delay. A motion to postpone the trial on account of the absence of evidence can be made only upon affidavit, showing the materiality of the evidence expected to be obtained, and that due diligence has been used to obtain it, and where the evidence may be. And if it is for an absent witness, the affidavit must show the name and residence of the witness, if known, and the probability of procuring the testimony within a reasonable time, and that his absence has not been procured by the act or connivance of the party, nor by others at his request, nor with his knowledge and consent, and what facts he believes to be true, and that he is unable to prove such facts by any other witness whose testimony can be as readily procured. If, thereupon, the adverse party will consent that, on the trial, the facts shall be taken as true if the absent evidence is written or documentary, and, in case of a witness, that he will testify to said facts as true, the trial shall not be postponed for that cause, and in such case, the party against whom such evidence is used, shall have the right to impeach such absent witness, as in the case where the witness is present, or his deposition is used. Rule 54. Judgment. Costs. A definition form. Judgment, as used in these rules, includes a decree and any order from which an appeal lies. A judgment shall contain all matters required by Rule 58, but need not contain a recital of pleadings, the report of the master, or the record of prior proceedings. B. Judgment upon multiple claims or involving multiple parties. When more than one claim for relief is presented in an action, whether as a claim, counterclaim, cross-claim, or third-party claim, or when multiple parties are involved. The court may direct the entry of a final judgment as to one or more but fewer than all of the claims or parties only upon an express determination that there is no just reason for delay and upon an express direction for the entry of judgment. In the absence of such determination and direction, any order or other form of decision, however designated, which adjudicates fewer than all the claims or the rights and liabilities of fewer than all the parties shall not terminate the action as to any of the claims or parties, and the order or other form of decision is subject to revision at any time before the entry of judgment adjudicating all the claims and the rights and liabilities of all the parties. A judgment as to one or more but fewer than all of the claims or parties is final when the court in writing expressly determines that there is no just reason for delay, and in writing expressly directs entry of judgment. And an appeal may be taken upon this or other issues resolved by the judgment. But in other cases a judgment, decision or order as to less than all the claims and parties is not final. C. Demand for judgment. A judgment by default shall not be different in kind from or exceed an amount that paid for in the demand for judgment, except as to a party against whom a judgment is entered by default. Every final judgment shall grant the relief to which the party in whose favor it is rendered is entitled, even if the party has not demanded such relief in his pleadings. D. Costs. Except when express provision therefor is made either in a statute or in these rules, costs shall be allowed as of course to the prevailing party unless the court otherwise directs in accordance with any provision of law. But costs against any governmental organization, its officers, and agencies shall be imposed only to the extent permitted by law. Costs may be computed and taxed by the clerk on 1 day's notice. On motion served within 5 days thereafter, the action of the clerk may be reviewed by the court. E. Judgments severable. Unless otherwise specified therein, judgments against two or more persons or upon two or more claims shall be deemed joint and several for purposes of 1. Permitting enforcement proceedings jointly or separately against different parties or jointly or separately against their property, or 2. Permitting one or more parties to challenge the judgment by appeal, motion and the like as against one or more parties as to one or more claims or parts of claims. Nothing herein is intended to dispense with notice requirements, or provisions requiring or permitting parties to join or participate in the same appeal. Rule 55. Default. A. Entry. When a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise comply with these rules and that fact is made to appear by affidavit or otherwise, the party may be defaulted by the court. B. Default judgment. In all cases the party entitled to a judgment by default shall apply to the court therefor. But no judgment by default shall be entered against a person 1. known to be an infant or incompetent unless represented in the action by a general guardian, committee, conservator, or other such representative who has appeared therein, or 2. entitled to the protections against default judgments provided by the Servitia Members' Civil Relief Act, as amended, the Act, 50 Us. Cx. Paragraph 521, unless the requirements of the Act have been complied with. See Ind. Small Claims Rule 10(b)(3). If the party against whom judgment by default is sought has appeared in the action, he or, if appearing by a representative, his representative shall be served with written notice of the application for judgment at least 3 days prior to the hearing on such application. If, in order to enable the court to enter judgment or to carry it into effect, it is necessary to take in account or to determine the amount of damages or to establish the truth of any averment by evidence or to make an investigation of any other matter, the court may conduct such hearing or order such references as it deems necessary and proper and shall accord a right of trial by jury to the parties when is required. C. Setting aside default. A judgment by default which has been entered may be set aside by the court for the grounds and in accordance with the provisions of Rule 60(b). D. Plaintiff, counterclaimants, cross-claimants. The provisions of this rule apply whether the party entitled to the judgment by default is a plaintiff, a third-party plaintiff, or a party who has pleaded a cross-claim or counterclaim. In all cases a judgment by default is subject to the limitations of Rule 54(c). E. Judgment against governmental organizations. A judgment by default may be entered against a governmental organization. Rule 56. Summary judgment. A. For claimant. A party seeking to recover upon a claim, counterclaim, or cross-claim or to obtain a declaratory judgment may, at any time after the expiration of 20 days from the commencement of the action or after service of a motion for summary judgment by the adverse party, move with or without supporting affidavits for a summary judgment in his favor upon all or any part thereof. B. For defending party when motion not required. A party against whom a claim, counterclaim, or cross-claim is asserted or a declaratory judgment is sought may, at any time, move with or without supporting affidavits for a summary judgment in his favor as to all or any part thereof. When any party has moved for summary judgment, the court may grant summary judgment for any other party upon the issues raised by the motion although no motion for summary judgment is filed by such party. C. Motion and proceedings thereon. The motion and any supporting affidavits shall be served in accordance with the provisions of Rule 5. An adverse party shall have 30 days after service of the motion to serve a response and any opposing affidavits. The court may conduct a hearing on a motion. However, upon motion of any party made no later than 10 days after the response was filed or was due, the court shall conduct a hearing on the motion which shall be held not less than 10 days after the time for filing the response. At the time of filing the motion or response, a party shall designate to the court all parts of pleadings, depositions, answers to interrogatories, admissions, matters of judicial notice, and any other matters on which it relies for purposes of the motion. A party opposing the motion shall also designate to the court each material issue of fact which that party asserts precludes entry of summary judgment and the evidence relevant thereto. The judgment sought shall be rendered forthwith if the designated evidentiary matter shows that there is no genuine issue as to any material fact and that the moving party is entitled to a judgment as a matter of law. A summary judgment may be rendered upon less than all the issues or claims, including without limitation the issue of liability or damages alone, although there is a genuine issue as to damages or liability as the case may be. A summary judgment upon less than all the issues involved in a claim or with respect to less than all the claims or parties shall be interlocutory unless the court in writing expressly determines that there is no just reason for delay in writing expressly directs entry of judgment as to less than all the issues, claims or parties. The court shall designate the issues or claims upon which it finds no genuine issue as to any material facts. Summary judgment shall not be granted as of course because the opposing party fails to offer opposing affidavits or evidence, but the court shall make its determination from the evidentiary matter designated to the court. D. Case not fully adjudicated on motion. If on motion under this rule judgment is not rendered upon the whole case or for all the relief asked in a trial as necessary, the court at the hearing of the motion, by examining the pleadings and the evidence before it and by interrogating counsel, shall if practicable ascertain what material facts exist without substantial controversy and what material facts are actually and in good faith controverted. It shall thereupon make an order specifying the facts that appear without substantial controversy, including to the extent to which the amount of damages or other relief is not in controversy, and directing such further proceedings in the action as are just. Upon the trial of the action the facts so specified shall be deemed established, and the trial shall be conducted accordingly. E. Form of affidavits. Further testimony defense required. Supporting and opposing affidavits shall be made on personal knowledge, shall set forth such facts as would be admissible in evidence, and shall show affirmatively that the affiant is competent to testify to the matters stated therein. Sworn or certified copies not previously self-authenticated of all papers or parts thereof referred to in an affidavit shall be attached thereto or served therewith. The court may permit affidavits to be supplemented or opposed by depositions, answers to interrogatories, or further affidavits. When a motion for summary judgment is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleading, but his response, by affidavits or as otherwise provided in this rule, must set forth specific facts showing that there is a genuine issue for trial. If he does not so respond, summary judgment, if appropriate, shall be entered against him. Denial of summary judgment may be challenged by a motion to correct errors after a final judgment or order is entered. F. When affidavits are unavailable. Should it appear from the affidavits of a party opposing the motion that he cannot for reasons stated present by affidavit facts essential to justify his opposition, the court may refuse the application for judgment or may order a continuance to permit affidavits to be obtained or depositions to be taken or discovery to be had or may make such other order as is just. G. Affidavits made in bad faith. Should it appear to the satisfaction of the court at any time that any of the affidavits presented pursuant to this rule are presented in bad faith or solely for the purpose of delay, the court shall forthwith order the party employing them to pay to the other party the amount of the reasonable expenses which the filing of the affidavits caused him to incur, including reasonable attorney's fees. and any offending party or attorney may be adjudged guilty of contempt. H. Appeal reversal. No judgment rendered on the motion shall be reversed on the ground that there is a genuine issue of material fact unless the material fact and the evidence relevant thereto shall have been specifically designated to the trial court. I. Alteration of time. For cause found, the court may alter any time limit set forth in this rule upon motion made within the applicable time limit. Rule 57. Declaratory judgments. The procedure for obtaining a declaratory judgment shall be in accordance with these rules, and the right to trial by jury may be demanded under the circumstances and in the manner provided in Rules 38 and 39. The existence of another adequate remedy does not preclude a judgment for declaratory relief in cases where it is appropriate. Declaratory relief shall be allowed even though a property right is not involved. Affirmative relief shall be allowed under such remedy when the right thereto is established. The court may order a speedy hearing of an action for a declaratory judgment and may advance it on the calendar. Rule 58. Entry and content of judgment. A. Entry of judgment. Subject to the provisions of Rule 54b, upon a verdict of a jury, or upon a decision of the court shall promptly prepare and sign the judgment. And the clerk shall thereupon enter the judgment in the record of judgments and orders, and note the entry of the judgment in the chronological case summary and judgment docket. A judgment shall be set forth on a separate document, except that a judgment may appear upon the same document upon which appears the court's findings, conclusions, or opinion upon the issues. The entry of the judgment shall not be delayed for the taxing of costs. Attorneys may submit suggested forms of judgment to the court, and upon request of the court, shall assist the court in the preparation of a judgment, but the judgment shall not be delayed to await a resolution of issues by agreement of counsel. The judge failing promptly to cause the judgment to be prepared, signed and entered as provided herein may be compelled to do so by mandate. B. Content of judgment. Except in small claims cases, a judgment shall contain the following elements. 1. A statement of the submission indicating whether the submission was to a jury or to the court, whether the submission was upon default, motion, cross-claim, counterclaim or third-party complaint, and if the submission was to less than all issues or parties, such other matters as may be necessary to clearly state what issue is resolved or what party is bound by the judgment. 2. A statement of the appearances at the submission indicating whether the parties appeared in person, by counsel, or both, whether there was a failure to appear after notice, and whether the submission was conducted by telephone conference. 3. At the court's discretion and in such detail as it may deem appropriate. A statement of the court's jurisdiction over the parties in action and of the issues considered in sufficient particularity to enable any party affected by the judgment to raise in another action the defenses of merger, bar or claim or issue preclusion. 4. A statement in imperative form which clearly and concisely sets forth the relief granted, any alteration of status, any right declared, or any act to be done or not done. 5. The date of the judgment and the signature of the judge. C. Court records excluded from public access and confidential pursuant to the rules on access to court records. Every court that issues a judgment or order containing court records excluded from public access pursuant to the rules on access to court records shall comply with the provisions of Rule 7 of the Rules on Access to Court Records. D. Satisfaction/release of judgment. Upon payment in full of the judgment, including accrued interest and court costs. the judgment creditor shall file a satisfaction release of judgment, and the clerk shall note the satisfaction release of the judgment on the CCS and on the judgment docket. Based upon a review of the clerk's payment records, the clerk may, or at the verified request of the judgment debtor shall, issue a notice to the judgment creditor that a judgment, including accrued interest and court costs, has been paid in full and that the judgment should be satisfied released. The notice shall be sent to the judgment creditor and debtor at the address shown on the chronological case summary. The clerk shall note the issuance of the notice on the chronological case summary. If the judgment creditor does not agree that the judgment should be satisfied released, the judgment creditor shall, within 30 days of the date of the issuance of the notice, file a verified objection. If the judgment creditor does not file an objection or a satisfaction release of judgment, the judgment shall be deemed satisfied released and the clerk shall note the satisfaction release of the judgment on the chronological case summary and on the judgment docket. Rule 59. Motion to correct error. A motion to correct error when mandatory. A motion to correct error is not a prerequisite for appeal, except when a party seeks to address 1. Newly discovered material evidence, including alleged jury misconduct, capable of production within 30 days of final judgment which, with reasonable diligence, could not have been discovered and produced at trial, or 2. A claim that a jury verdict is excessive or inadequate. All other issues and grounds for appeal appropriately preserved during trial may be initially addressed in the appellate brief. B. Filing of motion. The motion to correct error, if any, may be made by the trial court, or by any party. C. Time for filing, service on judge. The motion to correct error, if any, shall be filed not later than 30 days after the entry of a final judgment is noted in the chronological case summary. A copy of the motion to correct error shall be served, when filed, upon the judge before whom the case is pending pursuant to Trial Rule 5. The time at which the court is deemed to have ruled on the motion is set forth in Trail 53.3. D. Errors raised by motion to correct error, and content of motion. Where used, a motion to correct error need only address those errors found in Trial Rule 59A(1) and 2. Any error raised, however, shall be stated in specific rather than general terms and shall be accompanied by a statement of facts and grounds upon which the error is based. The error claimed is not required to be stated under, or in the language of the basis for the motion allowed by this rule, by statute, or by other law. E. Statement in opposition to motion to correct error. Following the filing of a motion to correct error, a party who opposes the motion may file a statement in opposition to the motion to correct error not later than 15 days after service of the motion. The statement in opposition may assert grounds which show that the final judgment or appealable final order should remain unchanged. Or the statement in opposition may present other grounds which show that the party filing the statement in opposition is entitled to other relief. F. Motion to correct error granted. Any modification or setting aside of a final judgment or an appealable final order following the filing of a motion to correct error shall be an appealable final judgment or order. G. Cross errors. If a motion to correct error is denied, the party who prevailed on that motion may, in the appellate brief and without having filed a statement in opposition to the motion to correct error in the trial court, defend against the motion to correct error on any ground, and may first assert grounds for relief therein, including grounds falling within sections A(1) and 2 of this rule, In addition, if a notice of appeal rather than a motion to correct error is filed by a party, the opposing party may raise any grounds as cross errors and also may raise any reasons to affirm the judgment directly in the appellate brief, including those grounds for which a motion to correct error is required when directly appealing a judgment under Sections A(1) and (2) of this rule. H. Motion to correct error based on evidence outside the record. 1. When a motion to correct error is based upon evidence outside the record, the motion shall be supported by affidavits showing the truth of the grounds set out in the motion, and the affidavits shall be served with the motion. 2. If a party opposes a motion to correct error made under this subdivision, that party has 15 days after service of the moving party's affidavits in motion, in which to file opposing affidavits. 3. If a party opposes a motion to correct error made under this subdivision, that party has 15 days after service of the moving party's affidavits in motion, in which to file its own motion to correct errors under this subdivision, and in which to assert relevant matters which relate to the kind of relief sought by the party first moving to correct error under this subdivision. 4. No reply affidavits, motions, or other papers from the party first moving to correct errors are contemplated under this subdivision. I. Costs in the event a new trial is ordered. The trial court, in granting a new trial, may place costs upon the party who applied for the new trial, or a portion of the costs, or it may place costs abiding the event of the suit, or it may place all costs or a portion of the costs on either or all parties as justice and equity in the case may require after the trial court has taken into consideration the causes which made the new trial necessary. J. Relief granted on motion to correct error. The court, if it determines that prejudicial or harmful error has been committed, shall take such action as will cure the error, including without limitation the following with respect to all or some of the parties and all or some of the errors. 1. Grant a new trial. 2. Enter final judgment. 3. Alter, amend, modify or correct judgment. 4. Amend or correct the findings or judgment as provided in Rule 52b. 5. In the case of excessive or inadequate damages, enter final judgment on the evidence for the amount of the proper damages, grant a new trial, or grant a new trial subject to additor or remediator. 6. Grant any other appropriate relief, or make relief subject to condition. Or 7. In reviewing the evidence, the court shall grant a new trial if it determines that the verdict of a non-advisory jury is against the weight of the evidence, and shall enter judgment, subject to the provisions herein. If the court determines that the verdict of a non-advisory jury is clearly erroneous as contrary to or not supported by the evidence, or if the court determines that the findings and judgment upon issues tried without a jury or with an advisory jury are against the weight of the evidence. In its order correcting error, the court shall direct final judgment to be entered or shall correct the error without a new trial unless such relief is shown to be impracticable or unfair to any of the parties or is otherwise improper. And if a new trial is required, it shall be limited only to those parties and issues affected by the error unless such relief is shown to be impracticable or unfair. If corrective relief is granted, the court shall specify the general reasons therefor. When a new trial is granted because the verdict, findings or judgment do not accord with the evidence, the court shall make special findings of fact upon each material issue or element of the claim or defense upon which a new trial is granted. Such findings shall indicate whether the decision is against the weight of the evidence or whether it is clearly erroneous as contrary to or not supported by the evidence. if the decision is found to be against the weight of the evidence. The findings shall relate the supporting and opposing evidence to each issue upon which a new trial is granted. If the decision is found to be clearly erroneous as contrary to or not supported by the evidence, the findings shall show why judgment was not entered upon the evidence. K. Orders regarding services, programs, or placement of children alleged to be delinquents or alleged to be in need of services. No motion to correct error is allowed concerning orders or decrees issued pursuant to Indiana Code Sections 31-34-4-7 E, 31-34-19-6, 1 E, 31-37-5-8 F, or 31-37-18-9 B. Appeals of such orders and decrees shall proceed as prescribed by Indiana Appellate Rule 14.1. Rule 60. Relief from judgment or order. A. Clerical mistakes. Of its own initiative or on the motion of any party and after such notice, if any, as the court ordered, clerical mistakes in judgments, orders or other parts of the record and errors therein arising from oversight or omission may be corrected by the trial court at any time, or the notice of completion of clerk's record is filed under Appellate Rule 8. After filing of the notice of completion of clerk's record and during an appeal, such mistakes may be so corrected with leave of the court on appeal. B. Mistake, excusable neglect, newly discovered evidence, fraud, etc. On motion and upon such terms as are just, the court may relieve a party or his legal representative from a judgment, including a judgment by default, for the following reasons: 1. Mistake, surprise, or excusable neglect. 2. Any ground for a motion to correct error, including without limitation newly discovered evidence, which by due diligence could not have been discovered in time to move for a motion to correct errors under Rule 59. 3. Fraud, whether heretofore denominated intrinsic or extrinsic, misrepresentation, or other misconduct of an adverse party. 4. Entry of default or judgment by default was entered against such party who is served only by publication and who is without actual knowledge of the action and judgment, order or proceedings. 5. Except in the case of a divorce decree, the record fails to show that such party was represented by a guardian or other representative, and if the motion asserts and such party proves that at the time of the action he was an infant or incompetent person, and b. he was not in fact represented by a guardian or other representative, and c. the person against whom the judgment, order or proceeding is being avoided procured the judgment with notice of such infancy or incompetency, and, as against a successor of such person, that such successor acquired his rights therein with notice that the judgment was procured against an infant or incompetent, and d. no appeal or other remedies allowed under this subdivision have been taken or made by or on behalf of the infant or incompetent person, and e. the motion was made within 90 days after the disability was removed or guardian was appointed over his estate, and f. the motion alleges a valid defense or claim. 6. the judgment is void. 7. the judgment has been satisfied, released, or discharged, or a prior judgment upon which it is based has been reversed or otherwise vacated, or it is no longer equitable that the judgment should have prospective application, or 8. any reason justifying relief from the operation of the judgment, other than those reasons set forth in subparagraphs 1, 2, 3, and 4. The motion shall be filed within a reasonable time for reasons 5, 6, 7, and 8, and not more than 1 year after the judgment, order or proceeding was entered are taken for reasons 1, 2, 3, and 4. A movant filing a motion for reasons 1, 2, 3, 4, and 8 must allege a meritorious claim or defense. A motion under this subdivision B does not affect the finality of a judgment or suspend its operation. This rule does not limit the power of a court to entertain an independent action to relieve a party from a judgment, order or proceeding or for fraud upon the court. Writs of coram nobis, coram vobis, audita querela, and bills of review and bills in the nature of a bill of review are abolished, and the procedure for obtaining any relief from a judgment shall be by motion as prescribed in these rules or by an independent action. C. Appeal change of venue. A ruling or order of the court denying or granting relief, in whole or in part, by motion under subdivision B of this rule shall be deemed a final judgment, and an appeal may be taken therefrom as in the case of a judgment. No change of venue in such cases shall be taken from the judge or county except for cause shown by affidavit. D. Hearing and relief granted. In passing upon a motion allowed by subdivision B of this rule, the court shall hear any pertinent evidence, allow new parties to be served with summons, allow discovery, grant relief as provided under Rule 59 or otherwise as permitted by subdivision B of this rule. E. Infants, incompetents, and governmental organizations. Except as otherwise provided herein, this rule shall apply to infants, incompetents, and governmental organizations. The time for seeking relief against a judgment, order or proceeding allowed or recognized under subdivision B of this rule or any other statute shall not be taught or extended as to such persons. Rule 60.5. Mandate of funds. A. Scope of mandate. Courts shall limit their requests for funds to those which are reasonably necessary for the operation of the court or court-related functions. Mandate will not lie for extravagant, arbitrary or unwarranted. Disciplinary fees. Prior to issuing the order, the court shall meet with the mandated party to demonstrate the need for said funds. At any time in the process, the dispute may be submitted to mediation by agreement of the parties or by order of the Supreme Court or the special judge. B. Procedure. Whenever a court, except the Supreme Court or the Court of Appeals, desires to order either a municipality, a political subdivision of the state, or an officer of either to appropriate or to pay unappropriated funds for the operation of the court or court-related functions, such court shall issue and cause to be served upon such municipality, political subdivision or officer an order to show cause why such appropriation or payment should not be made. Such order to show cause shall be captioned Order for Mandate of Funds. The matter shall be set for trial on the merits of such order to show cause unless the legislative body, the chief executive officer or the affected officer files a waiver in writing of such a trial and agrees to make such appropriation or payment. The trial shall be without a jury, before a special judge of the court that made the order. There shall be no change of venue from the county or from the special judge appointed by the Supreme Court. The court shall promptly notify the Supreme Court of the entry of such order to show cause, and the Supreme Court shall then appoint as special judge an attorney who is not a current or former regular judge and who does not reside nor regularly practice law in the county issuing the order of mandate of funds or in any county contiguous thereto. If the appointed judge fails to qualify within 7 days after he has received notice of his appointment, the Supreme Court shall follow the same procedure until an appointed judge does properly qualify. unless expressly waived by the respondent in writing within 30 days after the entering of the trial judge's decree. A decree or order mandating the payment of funds for the operation of the court or court-related functions shall be automatically reviewed by the Supreme Court. Promptly on expiration of such 30-day period, the trial judge shall certify such decree together with either a stipulation of facts or an electronic transcription of the evidence to the Supreme Court. No motion to correct error nor notice of appeal shall be filed. No mandate order for appropriation or payment of funds made by any court other than the Supreme Court or Court of Appeals shall direct that attorney fees be paid at a rate greater than the reasonable and customary hourly rate for an attorney in the county. No mandate order shall be effective unless it is entered after trial as herein provided and until the order has been reviewed by the Supreme Court or such review is expressly waived as herein provided. Rule 61. Harmless error. No error in either the admission or the exclusion of evidence and no error or defect in any ruling or order in anything done or omitted by the court or by any of the parties is ground for granting relief under a motion to correct errors or for setting aside a verdict or for vacating, modifying or otherwise disturbing a judgment or order or for reversal on appeal, unless refusal to take such action appears to the court inconsistent with substantial justice. The court at every stage of the proceeding must disregard any error or defect in the proceeding which does not affect the substantial rights of the parties. Rule 62. Stay of proceedings to enforce a judgment. Execution. Execution may issue upon notation of a judgment in the chronological case summary except as otherwise provided in this rule hereinafter. During the pendency of an appeal the provisions of subdivision C of this rule govern the suspending, modifying, restoring, or granting of an injunction, the appointment of a receiver or, to the extent that a stay is not otherwise permitted by law upon appeal, any judgment or order for specific relief other than the payment of money. B. Stay of execution. In its discretion and on such conditions for the security of the adverse party as are proper, the court may stay the execution of any proceedings to enforce a judgment pending the filing and disposition of 1. A motion to correct error or to alter or amend a judgment made pursuant to Rule 59. 2. A motion for judgment in accordance with a motion for a judgment on the evidence made pursuant to Rule 50. 3. A motion for amendment to the findings or for additional findings or for a new trial or judgment made pursuant to Rule 52. 4. A motion for relief from a judgment or order made pursuant to Rule 60, or 5. An appeal. C. Stay of orders relating to injunctions, appointment of receivers and orders for specific relief. When an appeal is taken from an interlocutory or final judgment granting, dissolving or denying an injunction, the appointment of a receiver or, to the extent that a stay is not otherwise permitted by law upon appeal, from any judgment or order for specific relief other than the payment of money, the court to which the application is made in its sound discretion may suspend, modify, restore, or grant the injunction. The appointment of the receiver or the specific relief during the pendency of the appeal upon such terms as to bond or otherwise as it considers proper for the security of the rights of the adverse party. Nothing in this rule is intended to affect the original jurisdiction of the Supreme Court or the Indiana Court of Appeals. D. Stay upon appeal. 1. Procedure for obtaining. No appeal bond or other security shall be necessary to perfect an appeal from any judgment or appealable interlocutory order. Enforcement of a judgment or appealable interlocutory order will be suspended during an appeal upon the giving of an adequate appeal bond with approved sureties. an irrevocable letter of credit from a financial institution approved in all respects by the court, or other form of security approved by the court. The bond, letter of credit, or other security may be given at or after the time of filing the notice of appeal. The stay is effective when the appeal bond, letter of credit, or other form of security is approved by the appropriate court. The trial court or judge shall have jurisdiction to fix and approve the bond or letter of credit and order a stay pending an appeal as well as prior to the appeal. If the stay is denied by the trial court, the appellate tribunal may reconsider the application at any time after denial, and this provision also shall apply to stays or relief allowed under subdivision C of this rule. When the stay or relief is granted by the court on appeal, the clerk of the Supreme Court shall issue a certificate thereof to the clerk of the court below, who shall file it with the judgment or order below and deliver it to the sheriff or any officer to whom execution or an enforcement order has been issued. 2. Form of appeal bond or letter of credit. Whenever a party entitled thereto desires a stay on appeal, such party may present to the appropriate court for its approval an appeal bond or an irrevocable letter of credit from a financial institution. The bond or letter of credit shall be conditioned for the satisfaction of the judgment in full together with costs, interest, and damages for delay, if for any reason the appeal is dismissed or if the judgment is affirmed, and to satisfy in full such modification of the judgment and such costs, interest, and damages as the appellate court may adjudge and award. When the judgment is for the recovery of money not otherwise secured, the amount of the bond or letter of credit shall be fixed at such sum as will cover the whole amount of the judgment remaining unsatisfied, costs on the appeal, interest, and damages for delay, unless the court after notice and hearing and for good cause shown fixes a different amount or orders security other than a bond or letter of credit. When the judgment determines the disposition of the property in controversy is in real action, replevin, and actions to foreclose liens, or when such property is in the custody of the sheriff, or when the proceeds of such property or bond or letter of credit for its value is in the custody or control of the court, the amount of the appeal bond or letter of credit shall be fixed at such sum only as will secure the amount recovered for the use and detention of the property, the costs of the action, costs on appeal, interest, and damages for delay. 3. Effect of appeal bond or letter of credit. Nothing in this subdivision shall be construed as giving the right to stay, by giving such bond or letter of credit, any judgment or order which cannot now be stayed or suspended by the giving of an appeal bond, except as provided in subdivisions A, B, and C of this rule. The provisions in this rule do not limit any power of an appellate court or of a judge or justice thereof to stay proceedings during the pendency of an appeal or to suspend, modify, restore, or grant an injunction during the pendency of an appeal or to make any order appropriate to preserve the status quo or the effectiveness of the judgment subsequently to be entered. E. Stay in favor of governmental organization personal representative. When an appeal or review is taken by a governmental organization, or by a court-appointed representative of a decedent's estate, guardian, receiver, assignee for the benefit of creditors, trustee or other court-appointed representative, the operation or enforcement of the judgment shall be stayed as it would as against other persons upon application to the appropriate court, but no bond, obligation or other security shall be required. F. Stay of execution under existing laws. Other bonds required before or as a condition to judgment, money in lieu of bonds amount fixed by court. Execution upon a judgment for recovery of money or sale of property may be stayed, and personal property taken in execution may be delivered up as now provided by law. Indiana Acts, ch. 38, paragraph 493-506 and paragraph 531-536 spec.s.1881. FN1. Nothing in this rule is intended to alter the right of a party to the protection of a surety bond or security, or to obtain relief by furnishing a surety bond or security before or as a condition of final judgment, including without limitation such protection or relief in replevin, ejectment, attachment and injunction actions, upon judicial review of administrative action, and suits upon a lost instrument, for costs and the like. In any case where a surety bond, letter of credit, or security is furnished under this rule, the right to furnish money or a check in lieu of a bond shall remain unimpaired. Any requirement that the amount of the bond or letter of credit be fixed and reconsidered by the court in civil actions and proceedings shall remain unaffected by this rule. G. Effective stay or temporary relief when new trial granted. When an appealable judgment or order is entered against a party who has obtained a prior stay or temporary relief by furnishing a surety bond, letter of credit, or other security, including without limitation relief in replevin, ejectment, attachment and injunctive actions, such stay or temporary relief shall lapse except to the extent 1. Provided in subdivision A of this rule, or 2. A stay is granted as provided or recognized in this rule. If thereafter the order or judgment is reversed and a new trial or new hearing in fact is ordered or authorized in favor of such party, the original stay or relief shall not be reinstated unless the reversing court orders otherwise, or, in the absence of such order, the court on the new trial or new hearing orders otherwise. When a stay or temporary relief is granted to a party seeking reversal of an appealable order or judgment under subdivision B, C, or D of this rule and a new trial or new hearing in fact is ordered or authorized in favor of such party, the stay or temporary relief shall continue until the final appealable judgment or order is entered unless the court on review or appeal orders otherwise, or, in the absence of such order, the court on the new trial or new hearing orders otherwise. Nothing in this subdivision is intended to limit the liability of the bondsman, the financial institution issuing the letter of credit, or other security, or determine the order of liability assumed among different bondsmen or different security furnished in the course of proceedings before judgment, after judgment and after appeal or review. H. Stay of judgment as to multiple claims or multiple parties. When a court has ordered a final judgment under the conditions stated in Rule 54b, the court may stay enforcement of that judgment until the entering of a subsequent judgment or judgments, and may prescribe such conditions as are necessary to secure the benefit thereof to the party in whose favor the judgment is entered. Rule 63. Disability and unavailability of a judge. A. Disability and unavailability after the trial or hearing. The judge who presides at the trial of a cause or hearing at which evidence is received shall, if available, hear motions and make all decisions and rulings required to be made by the court relating to the evidence and the conduct of the trial or hearing after the trial or hearing is concluded. If the judge before whom the trial or hearing was held is not available by reason of death, sickness, absence or unwillingness to act, then any other judge regularly sitting in the judicial circuit or assigned with cause may perform any of the duties to be performed by the court after the verdict is returned or the findings or decision of the court is filed. But if he is satisfied that he cannot perform those duties because he did not preside at the trial or for any other reason, he may in his discretion grant a new trial or a new hearing, in whole or in part. The unavailability of any such trial or hearing judge shall be determined and shown by a court order made by the successor judge at any time. B. Judge pro tempore in case of disability, unavailability, or neglect. 1. When a judge of a court submits a verified petition and supporting proof to the Supreme Court stating that the judge is or will be unable to perform the duties of the office because of disability or other basis, e.g. order to military active duty, the Supreme Court shall promptly consider the petition. 2. When a person submits a verified petition to the Supreme Court stating that a judge of the court A is unable to perform the duties of the office because of disability or B has failed, refused, or neglected to perform these duties, the Supreme Court shall issue an order to the judge, accompanied by the petition, requiring the judge to show causes to why a judge pro tempore should not be appointed to perform the duties of the office. The order shall set a date for response and indicate that the judge may request a hearing. The order may include a date for such a hearing on or after the date set for response. The order shall be served at least 10 days before the date set for response. 3. If the Supreme Court is satisfied that a petition submitted under subsection 1 or 2 should be granted, it shall appoint a full-time judge pro tempore to perform the duties of the office until a. the term of the office is ended, b. the office becomes vacant, or c. the judge's ability to resume those duties is established. 4. A judge who seeks to resume the duties of the office shall submit a verified petition and supporting proof to the Supreme Court. The judge may request a hearing on the petition. 5. The Supreme Court may order a judge who has submitted a petition under subsection 1 to demonstrate that the judge is or remains unable to perform the duties of the office. C. Qualifications and authority of a judge pro tempore. Any judge appointed under this or any other rule or law shall be an attorney in good standing at the bar of the Supreme Court of this state. In the event the Supreme Court of the state shall appoint a judge pro tempore under these provisions, a duly certified copy of the order and judgment of appointment of such judge pro tempore, attested by the Chief Justice, shall be issued to the person so appointed. If the person so appointed consents to serve, he shall be qualified as other judges are qualified. A certified copy of the order and judgment of appointment shall be filed with the clerk of the named court and entered in the appropriate records of said court. The person so appointed and qualified as a judge pro tempore shall perform the duties of the regular judge of the court, but always shall be subject to the continuing jurisdiction of the Supreme Court. In the event any judge pro tempore, appointed under the provisions of this rule shall fail to qualify and assume the duties of the regular judge of such court, or in the event such judge pro tempore fails to conduct the business of the court as provided by law, the clerk of the court shall notify the Supreme Court in writing of this fact. Upon the receipt of such notification, the Supreme Court may take such action in the premises, in order to further the administration of justice, as such court may deem to be necessary and just. D. Compensation of judge pro tempore. A judge pro tempore appointed by the Supreme Court under this rule shall receive a salary computed at the same rate as the regular judge commencing from the date he qualifies. A judge pro tempore appointed locally shall be paid $25 for each day or part thereof actually served. The judge pro tempore shall be paid out of the respective county, city or town general fund, without an appropriation therefor, upon allowance by the Board of County Commissioners of the county or council of the city or town in which the court is located. If he is appointed locally, the judge pro tempore shall present a claim to the Board of County Commissioners specifying the number of days or parts of days actually served, which claim shall be verified by the clerk of the court, and the board shall allow he claim. If he is appointed by the Supreme Court, the judge shall present a claim to the board with a copy of his appointment from the Supreme Court, a statement showing the date of his qualification verified by the clerk, and a request that he be paid in the same manner thereafter as a regular judge, and thereafter he shall be paid in the same manner as a regular judge. Nothing herein shall be construed to diminish in any manner the compensation of any regular judge so long as such regular judge continues in office. Judge pro tempore when judge is unable to attend. A judge who is unable to attend and preside at his court for any cause may appoint in writing a judge pro tempore to conduct the business of this court during his absence. The written appointment shall be entered in the records of the court. When duly sworn, or without being sworn, if he is a judge of a court of this state, the judge pro tempore shall have the same authority during the period of his appointment as the judge he replaces. A judge appointed under this provision must meet the qualifications prescribed in subdivision C of this rule. Such judge shall be allowed the sum of $25.00 for each day or part thereof actually served, per diem as provided in Rule 79 p and in the manner provided by subdivision D of this rule. In his absence or when he shall be unable to make such appointment, the appointment may be made by the clerk of his court, or the deputy clerk assigned to his court, or in his absence by any available county officer. Rule 63.1. Lis pendens notice of proceedings avoiding judgments and circumstances tolling and extending statutes of limitations. Assignments and discharges in lis pendens and judgment dockets. Lis pendens notices in cases involving interest in personal property. A lis pendens notice of avoidance of judgment and tolling of statute of limitations affect a failure to file notice thereof. Avoidance of, or proceedings to avoid a final judgment by a subsequent motion for judgment on the evidence. Rule 50. For amendment of the finding or judgment. Rule 52. And to correct errors. Rule 59. By proceedings for relief from a judgment under Rule 60b or under the appellate rules, and the tolling or extension of the statute of limitations or other bar of a claim to the property shall be ineffective against the purchaser of an interest in land, or a purchaser or lien creditor who acquires an interest in personal property and who claims such interest under or because of such judgment, such tolling or such extension if 1. The purchaser of land gives value and perfects of record or takes possession of the land in good faith and without notice of the avoidance, tolling or extension while the person against whom he claims is not in possession of the land and before he has filed a notice in the lis pendens record of the county where the land is located, or 2. The purchaser or lien creditor acquiring an interest in personal property as a buyer would take priority over an unperfected security interest while the person against whom he claims has not perfected by possession and before he has filed a financing statement containing lis pendens notices provided in subdivision C of this rule. The lis pendens notice shall be signed by the party or his attorney seeking avoidance of the judgment or the party with the claim asserted to be tolled. Identify the judgment by court and docket number. Describe the claim in terms which will lead to the records where any evidence thereof is filed or recorded if such is the case. Name the parties. In the case of land, designate a present record owner thereof if the parties named are not such owner or owners. And describe the land or personal property if the judgment or claim relates to described land or personal property. b. Satisfactions and assignments of docketed judgments and matters entered in lis pendens record. A satisfaction, dismissal, release or assignment of claims or matters recorded or filed in the lis pendens record relating to land or of a judgment entered in the judgment docket may be e-filed or recorded and indexed in the same manner as originally filed, recorded or docketed, and for the same fees provided that such satisfaction, dismissal, release or assignment is 1. In writing, describing the judgment by cause number, signed by the person executing it and acknowledged as in the case of a deed, or 2. In writing certified as entered in as records by the clerk of court where the judgment is entered or the action is pending. 3. Entered in writing upon the margin of the record signed by the person executing it and attested by the clerk's signature. A satisfaction, continuation, dismissal, release or assignment of a lis pendens notice filed in the case of personal property is sufficient if it meets the requirements of a termination statement, continuation statement, assignment or release of a financing statement. C. Constructive notice of lis pendens against personal property and rights of lien creditors. Judicial proceedings brought by a creditor to enforce an unperfected interest in personal property and a lien obtained by judicial proceedings, including tax and other liens through judicial records in personal property, shall not serve as constructive or lis pendens notice thereof until possession is acquired by the creditor or by a court officer, or until notice thereof by the creditor is perfected by filing a financing statement. 1. Naming the defendant as debtor, and the creditor as secured party. 2. Briefly describing the collateral in such words as a lien upon debtor's personal property by judicial proceedings, and indicating the kind or type of property, along with the court and cause number of the action. 3. Signed by the creditor or judgment creditor. And 4. In the filing office or offices where financing statement under a security agreement with respect to the collateral, if filed, would be required to be filed. Lis pendens notice under this provision is subject to principles of estoppel or commercial law governing negotiable instruments and documents, securities or quasi-negotiable instruments or documents, and to the provisions of Article 9 the Uniform Commercial Code FN1 relating to the duration of filing. In an appropriate case, the debtor or judgment debtor shall be entitled to a termination statement when judgment in his favor becomes final or when a lien obtained by judicial proceedings is terminated or is satisfied, as in the case of a debtor under a security agreement. D. Effect of judgment on lis pendens notice. A properly filed lis pendens notice of a claim against property continues to be perfected with respect to a judgment establishing such claim for the duration of the judgment, subject to the duration of filing under subdivision C of this rule. FN1, IC 26-1-9-101 at SEC. Rule 64. Seizure of person or property. A. Ancillary remedies to assist in enforcement of judgment. 1. At the commencement of and during the course of an action. All remedies providing for seizure of person or property for the purpose of securing satisfaction of the judgment ultimately to be entered in the action are available under the circumstances and in the manner provided by law and existing at the time the remedy is sought. The remedies thus available include, without limitation, arrest, attachment and garnishment, lis pendens notice, ejectment, replevin, sequestration, and other corresponding or equivalent legal or equitable remedies, however designated, and regardless of whether by existing procedure the remedy is ancillary to an action or must be obtained by an independent action. Such remedies are subject to the provisions of this rule, and, except as herein otherwise provided, the action in which any of the foregoing remedies is used shall be commenced and prosecuted pursuant to these rules. 2. The court may issue a writ of attachment, bench warrant, or body attachment if a rule to show cause has been issued by the court and served upon the judgment debtor by delivering a copy of the same to the judgment debtor personally. Personal service under this rule includes certified mail signed by the judgment debtor. B. If service is not made in open court, the person making service has filed a return or affidavit stating that personal service was made upon the judgment debtor and setting forth the time, place, and manner thereof. And C. The judgment debtor has failed to appear at the rule to show cause hearing as ordered. In addition to statutory requirements, the writ of attachment, bench warrant, or body attachment shall contain sufficient information to identify the judgment debtor. 3. A person taken into custody in a civil action must be brought before the court that issued the writ, bench warrant or body attachment, or before a judicial officer having jurisdiction over the person within 48 hours, excluding weekends and holidays, following the person being taken into custody. The person shall be advised of the procedures for release, including any bond, escrow amount set by the issuing court in the writ, bench warrant or body attachment. B. Attachment or attachment and garnishment. Attachment or attachment and garnishment shall be allowed in the following cases in addition to those where such remedies prior to judgment are now permitted by law. 1. It shall be a cause for attachment that the defendant or one of several defendants is a foreign corporation, a non-resident of this state, or a person whose residence and whereabouts are unknown and cannot be determined after reasonable investigation before the commencement of the action. 2. Any interest in tangible or intangible property owned by the defendant shall be subject to attachment or attachment and garnishment, as the case may be, if it is subject to execution, proceedings supplemental to execution or any credit or process allowed by law. Wages or salaries shall not be subject to prejudgment attachment and garnishment, except as otherwise provided by law. 3. Attachment or attachment and garnishment shall be allowed in favor of the plaintiff suing upon a claim for money, whether founded on contract, tort, equity or any other theory, and whether it is liquidated, contingent or unliquidated, or upon a claim to determine the rights in the property or obligation attached or garnished. 4. It shall not be objectionable that the property or obligation being attached or garnished is in the possession of the plaintiff or is owing by the plaintiff to the defendant or by the defendant to the plaintiff. 5. A governmental organization, or representative, including a guardian, receiver, assignee for the benefit of creditors, trustee or representative of a decedent's estate may be named as a garnishee and bound by the duties of a garnishee. 6. A writ of attachment against the defendant's real estate or his interest therein is effectively served by recordation of notice of the action in the appropriate lis pendens record, and, unless vacant, by serving the writ of attachment or notice thereof upon a person in possession of the land. C. Defendant's title raised by denial effect of dismissal. In action where the plaintiff is required to establish title to any fund or property, including without limitation any ejectment, replevin, quiet title, partition, equitable, legal or other action, the defendant in his answer may deny the plaintiff's claim of title and thereby place in issue the defendant's title or interest therein. If the defendant prevails under such an answer, he shall be entitled to a judgment or decree enunciating his title or interest and any proper negative or affirmative relief against the plaintiff consistent with his proof. Unless the defendant joins in the notice of dismissal, No voluntary dismissal by the plaintiff in such cases shall be allowed without prejudice after the plaintiff has obtained possession of the property or fund or other relief with respect thereto by posting bond, or after the defendant by answer, whether by denial, affirmative defense, counterclaim or cross-claim, has placed title in issue. Rule 65. Injunctions. A preliminary injunction. 1. Notice. No preliminary injunction shall be issued without an opportunity for a hearing upon notice to the adverse party. 2. Consolidation of hearing with trial on merits. Before or after the commencement of the hearing of an application for a preliminary injunction, the court may order the trial of the action on the merits to be advanced and consolidated with the hearing of the application. Even when this consolidation is not ordered, any evidence received upon an application for a preliminary injunction which would be admissible upon the trial on the merits becomes part of the record on the trial and need not be repeated upon the trial. 3. Assignment of cases judged to act promptly. Assignment of cases shall not be affected by the fact that a temporary restraining order or preliminary injunction is sought, but such case shall be assigned promptly, and the judge regularly assigned to the case shall act upon and hear all matters relating to temporary restraining orders and preliminary injunctions. The judge shall make himself readily available to consider temporary restraining orders, conduct hearings, fix the manner of giving notice and the time and place for hearings under this rule, and shall act and require the parties to act promptly. If the party seeking relief or his attorney by affidavit establishes that the judge assigned to the case is not available or cannot be found to consider an application for a restraining order, to conduct a hearing, or to fix the manner of giving notice and the time and place for a hearing under this rule, he may apply to any other judge in the circuit who shall take all further action with respect to any temporary restraining order or preliminary injunction. If the affidavit establishes that no other judge in the circuit is available or to be found, he may apply to the judge of any adjoining circuit. Unless an order is entered within 10 days after the hearing upon the granting, modifying or dissolving of a temporary or preliminary injunction, the relief sought shall be subject to the provisions of Rule 53.1. 4. Modification of orders. Responsive pleadings. Upon the court's own motion or the motion of any party, orders granting or denying temporary restraining orders or preliminary injunctions may be dissolved, modified, granted or reinstated. Responsive pleadings shall not be required in response to any pleadings or motions relating to temporary restraining orders or preliminary injunctions. B. Temporary restraining order notice. Hearing duration. A temporary restraining order may be granted without written or oral notice to the adverse party or his attorney only if 1. It clearly appears from specific facts shown by affidavit or by the verified complaint that immediate and irreparable injury, loss, or damage will result to the applicant before the adverse party or his attorney can be heard in opposition, and 2. The applicant's attorney certifies to the court in writing the efforts, if any, which have been made to give notice and the reasons supporting his claim that notice should not be required. Every temporary restraining order granted without notice shall be endorsed with the date and hour of issuance, shall be filed forthwith in the clerk's office and entered of record, shall define the injury and state why it is irreparable and why the order was granted without notice, and shall expire by its terms within such time after entry, not to exceed 10 days, as the court fixes, unless within the time so fixed the order, for good cause shown. is extended for a like period, or unless the whereabouts of the party against whom the order is granted is unknown and cannot be determined by reasonable diligence, or unless the party against whom the order is directed consents that it may be extended for a longer period. The reasons for the extension shall be entered of record. In case a temporary restraining order is granted without notice, the motion for a preliminary injunction shall be set down for hearing at the earliest possible time and takes precedence of all matters except older matters of the same character. And when the motion comes on for hearing, the party who obtained the temporary restraining order shall proceed with the application for a preliminary injunction, and, if he does not do so, the court shall dissolve the temporary restraining order. On 2 days' notice to the party who obtained the temporary restraining order without notice, or on such shorter notice to that party as the court may prescribe, the adverse party may appear and move its dissolution or modification, and in that event the court shall proceed to hear and determine such motion as expeditiously as the ends of justice require. C. Security. No restraining order or preliminary injunction shall issue except upon the giving of security by the applicant, in such sum as the court deems proper, for the payment of such costs and damages as may be incurred or suffered by any party who is found to have been wrongfully enjoined or restrained. No such security shall be required of a governmental organization, but such governmental organization shall be responsible for costs and damages as may be incurred or suffered by any party who is found to have been wrongfully enjoined or restrained. The provisions of Rule 65.1 apply to a surety upon a bond or undertaking under this rule. D. Form and scope of injunction or restraining order. Every order granting temporary injunction and every restraining order shall include or be accompanied by findings as required by Rule 52, shall be specific in terms, shall describe in reasonable detail, and not by reference to the complaint or other document, the act or acts sought to be restrained, and is binding only upon the parties to the action, their officers, agents, servants, employees, and attorneys, and upon those persons in active concert or participation with them who receive actual notice of the order by personal service or otherwise. E. Temporary restraining orders. Domestic relations cases. Parties wishing protection from domestic or family violence in domestic relations cases shall petition the court pursuant to Act 34-26-5. Subject to the provisions set forth in this paragraph, in an action for dissolution of marriage, separation, or child support, the court may issue a temporary restraining order, without hearing or security, if either party files a verified petition alleging an injury would result to the moving party if no immediate order were issued. 1. Joint order. If the court finds that an order shall be entered under this paragraph, the court may enjoin both parties from transferring, encumbering, concealing, selling or otherwise disposing of any joint property of the parties or asset of the marriage except in the usual course of business or for the necessities of life, without the written consent of the parties of the permission of the court, and or b. Removing any child of the parties then residing in the state of Indiana from the state with the intent to deprive the court of jurisdiction over such child without the prior written consent of all parties or the permission of the court. 2. Separate order required. In the event a party seeks to enjoin by a temporary restraining order the non-moving party from abusing, harassing, or disturbing the peace of the petitioning party or any child or stepchild of the parties, or exclude the non-moving party from the family dwelling, the dwelling of the non-moving party, or any other place, and the court determines that an order shall be issued, such order shall be addressed to one person, A joint or mutual restraining order shall not be issued. If both parties allege injury, they shall do so by separate petitions. The trial court shall review each petition separately and grant or deny each petition on its individual merits. In the event the trial court finds cause to grant both petitions, it shall do so by separate orders. 3. Effect of order. An order entered under this paragraph is automatically effective upon service. Such orders are enforceable by all remedies provided by law, including contempt. Once issued, such orders remain in effect until the entry of a decree or final order or until modified or dissolved by the court. F. Statutory provision unaffected by this rule. Nothing in this rule shall affect provisions of statutes extending or limiting the power of a court to grant injunctions. By way of example, and not by way of limitation, this rule shall not affect the provisions of 1967 Indiana Acts, ch. 357, paragraph 1-8, FN1 relating to public lawsuits, and Indiana Acts, ch. 7. Paragraph 1-15, FN2, providing for removal of injunctive and mandamus actions to the Court of Appeals of Indiana, and Indiana Acts, ch. Rule 65.1. Security, proceedings against sureties. Whenever these rules or other laws require or permit the giving of security by a party to a court action or proceeding, and security is given in the form of a bond or stipulation or other undertaking with one or more sureties, each surety submits himself to the jurisdiction of the court and irrevocably appoints the clerk of the court as his agent, upon whom any papers affecting his liability on the bond or undertaking may be served. His liability may be enforced on motion without the necessity of an independent action. The motion and such notice of the motion as the court prescribes may be served on the clerk of the court, who shall forthwith mail copies to the sureties if their addresses are known. This rule applies to bonds or security furnished on appeal, and enforcement shall be in the court to which the case is returned after appeal. Rule 66. Receivers, assignees for the benefit of creditors and statutory and other liquidators. Claims against such officers. A. Actions. Appointment. Procedure. An action wherein a receiver, assignee for the benefit of creditors or statutory or other liquidator has been appointed as shall not be dismissed except by order of the court. Administration of such estates shall be in accordance with the practice heretofore followed. In all other respects, the action in which the appointment of such officer is sought or which is brought by or against him is governed by these rules. B. Statement of assets and liabilities. Whenever a receiver, assignee for the benefit of creditors, statutory or other liquidator shall have been appointed to take over the business or assets of any person, organization, or partnership, the court appointing such officer may, or upon petition of any interested person shall, fix a time within which the person, or members, owners, agents or officers of the business or assets so placed in the hands of the officer, shall file with the clerk of the court in which such proceedings are had, a full, complete, itemized statement in affidavit form, setting forth in detail all the assets and all the liabilities of such person, organization or partnership, including a list of the names and addresses of all known creditors. In case of non-compliance, the statement shall be prepared by the liquidator. C. Notice of appointment time within which to file claims. After such statement is filed, such officer shall give reasonable notice of his appointment by publication as ordered by the court, and the receiver shall mail a copy of said notice to all creditors listed on the statement so filed or prepared. Said notice shall state the date of appointment of the receiver and the period of time, as shall have been fixed by the court, within which creditors may file claims. Said period of time shall not be less than 6 months from said date of appointment. D. Claims. The procedure for the filing, consideration, allowance or trial of claims and receiverships and assignments for the benefit of creditors, or statutory or other liquidations, shall, insofar as is practicable, conform with the procedure relating to claims in decedent's estates. E. Claims which must be paid without filing. A receiver, assignee for the benefit of creditors, statutory or other liquidator shall pay or make distributions according to priorities as required by law upon all claims, whether properly filed or filed within the allowed time after the appointment of the officer, if 1. Liquidated an amount or capable of liquidation by a mathematical computation. 2. The claim was owing and could have been filed and proved after the officer's appointment. And 3. It is shown to be unpaid or owing upon the books or records of the debtor regularly and currently maintained for the purpose of showing the status of claims of such class. Payment or distribution hereunder may be recovered by the officer or his successor to the extent it was excessive, not owing, or not payable. Upon petition of any interested person or the officer prior to final distribution or along with a petition for final distribution, the court may determine the existence or non-existence of claims subject to this subdivision and may issue appropriate orders for payment or non-payment as the case may be. Rule 67. Deposit in court. Payment of judgment. A deposit in court before judgment. Before judgment in an action in which any part of the relief sought is a judgment for a sum of money or the disposition of a sum of money or the disposition of any other thing capable of delivery, a party, upon notice to every other party, and by leave of court, may deposit with the court all or any part of such sum or thing. Payment of all or part thereof may be directed by the court under any judgment or order, or upon motion and hearing to the rightful owners, or upon security or agreement of the parties under the direction of the court. B. Payment of judgment satisfaction entered of record. Unless otherwise directed by the court, payment of money owing under and following a judgment may be made to the judgment creditor or his attorney, to the sheriff holding a writ of execution, or to the clerk of the court where the judgment is rendered. If paid to the clerk shall notify the person entitled thereto or his attorney and shall pay such sum to him upon receiving a statement of satisfaction required herein. Money received by the sheriff towards satisfaction of the judgment shall be delivered to the clerk of the court where the judgment is rendered, who shall then proceed as if the money were paid to him. A party or person receiving payment or satisfaction of a judgment shall furnish to the sheriff, clerk, party or person making payment a signed statement of total or partial satisfaction and any necessary assignment identifying the judgment by cause number and acknowledged as in the case of a deed which, when acquired or delivered to the clerk, shall be entered in the records with the judgment. Such statement or any other entry by the clerk showing an assignment, payment or satisfaction of the judgment when certified by the clerk shall be received as evidence thereof, may be filed in the lis pendens record or judgment docket as provided in Rule 63.1b, and when so filed shall serve as constructive notice thereof. Rule 68. Offer of judgment. At any time more than 10 days before the trial begins, a party defending against a claim may serve upon the adverse party an offer to allow judgment to be taken against him for the money or property or to the effect specified in his offer, with costs then accrued. If within 10 days after the service of the offer the adverse party serves written notice that the offer is accepted, either party may then file the offer and notice of acceptance together with proof of service thereof, and thereupon the clerk shall enter judgment. An offer not accepted shall be deemed withdrawn, and evidence thereof is not admissible except in a proceeding to determine costs. If the judgment finally obtained by the offeree is not more favorable than the offeree must pay the costs incurred after the making of the offer. The fact that an offer is made but not accepted does not preclude a subsequent offer. When liability of one party to another has been partially determined by verdict or order of judgment, but the amount or extent of liability remains to be determined by further proceedings, the party adjudged liable may make an offer of judgment, which shall have the same effect as an offer made before trial if it is served within a reasonable time not less than 10 days prior to the commencement of hearings to determine the amount or extent of liability. Rule 69. Execution, proceedings supplemental to execution, foreclosure sales. Execution sales. Process to enforce a judgment or a decree for the payment of money shall be by writ of execution, unless the court directs otherwise and except as provided herein. Notwithstanding any statute to the contrary, real estate shall not be sold until the elapse of 6 months from the time the judgment or execution thereon becomes a lien upon the property. The sale of real estate shall be conducted under the same rules and the same procedures applicable to foreclosure of mortgages, including subdivision (COF). This rule, without right of redemption after the sale, but subject to the judgment debtor's right to care for and remove crops growing at the time the lien attached, as in the case of mortgage foreclosure. Unless otherwise ordered by the court, the sheriff or person conducting the sale of any property upon execution shall not be required to offer it for sale in any particular order, in parcels, or first offer rents and profits, and shall be required to sell real and personal property separately pursuant to the law applicable. Execution upon any property shall not suspend the right and duty to levy upon other property. B. Judgment and execution liens on after acquired property. In the case of property acquired by the debtor after prior judgment or execution, liens have been perfected, such liens shall share pro rata with each other without further levy. C. Foreclosure of liens upon real estate. Unless otherwise ordered by the court, judicial foreclosure of all liens upon real estate shall be conducted under the same rules and the same procedures applicable to foreclosure of mortgages upon real estate, including without limitation redemption rights, manner and notice of sale, appointment of a receiver, execution of deed to purchaser, and without valuation and apprisement. Judicial lien foreclosures including mortgage foreclosures may be held at any reasonable place stated in the notice of sale. In all cases where a foreclosure or execution sale of realty is not confirmed by the court, the sheriff or other officer conducting the sale shall make a record of his actions therein in his return, to be filed promptly with the record of the case and also in the execution docket maintained in the office of the clerk. D. Other judicial sales. Unless otherwise ordered by TCR, all public judicial sales of real estate, other than lien and mortgage foreclosures and execution sales, shall, to the extent possible, be sold in the same manner that real estate is sold in the administration of decedent's estates, and subject to the same rules applicable to the manner and effect thereof. This provision shall apply, without limitation, to judicial sales by trustees, guardians, receivers, assignees for the benefit of creditors, and sales in partition proceedings. E. Proceedings supplemental to execution. Notwithstanding any other statute to the contrary, Proceedings supplemental to execution may be enforced by verified motion or with affidavits in the court where the judgment is rendered, alleging generally 1. That the plaintiff owns he described judgment against the defendant. 2. That the plaintiff has no cause to believe that levy of execution against the defendant will satisfy the judgment. 3. That the defendant be ordered to appear before the court to answer as to his non-exempt property subject to execution or proceedings supplemental to execution, or to apply any such specified or unspecified property towards satisfaction of the judgment. And 4. If any person is named as garnishee, that garnishee has or will have specified or unspecified non-exempt property of, or an obligation owing to the judgment debtor subject to execution or proceedings supplemental to execution, and that the garnishee be ordered to appear and answer concerning the same, or answer interrogatory submitted with the motion. If the court determines that the motion meets the foregoing requirements, it shall, ex parte and without notice, order the judgment debtor, other named parties, defendant and the garnishee, to appear for a hearing thereon or to answer the interrogatories attached to the motion, or both. The motion, along with the court's order stating the time for the appearance and hearing or the time for the answer to interrogatory submitted with the motion, shall be served upon the judgment debtor as provided in Rule 5. And other parties and the garnishee shall be entitled to service of process as provided in Rule 4. The date fixed for appearance and hearing or answer to interrogatories shall be not less than 20 days after service. No further pleadings shall be required, and the case shall be heard and determined in property ordered applied towards the judgment in accordance with statutes allowing proceedings supplementary to execution, in aid of the judgment or execution. The judgment creditor or his successor in interest of record in the judgment debtor may utilize the discovery provisions of these rules in the manner provided in these rules for discovery or as provided under the laws allowing proceedings supplemental. Writs of attachment, bench warrants, and BOD attachments are governed by Trial Rule 64A. F. Title opinion or insurance required in all judicial sales of land. In the case of any judicial sale of land, including without limitation mortgage and lien foreclosures, execution sales, sales by receivers, assignees for the benefit of creditors, guardians or trustees, or partition sales, upon motion the court at its discretion may order the judgment creditor, person seeking the sale, or officer conducting the sale to procure a qualified title opinion or a title insurance policy from a title insurance company authorized to do business in Indiana with respect to the interest of the person whose land is being sold. The policy must be conditioned to cover the purchase price at the sale and may be given with any necessary exclusions. The opinion or policy shall run to all parties interested in the litigation and to any purchaser or purchasers at the sale. The opinion or policy or copy thereof shall be available for inspection in the court from which the sale is being conducted or in the office of the court officer conducting the sale at the first notice of sale and shall be made available for inspection at the sale. Expenses of the opinion or policy shall be taxed as costs like other expenses of the sale and paid from the first proceeds of the sale. The opinion or policy shall not cover defects arising in the conduct of the sale. Rule 70. Judgment for specific acts. Vesting title. Recordation. A effect of judgment. If a judgment directs a party to execute a conveyance of land, or other property, or to deliver deeds or other documents, or to perform any other specific act and the party fails to comply within the time specified, The court may direct the act to be done at the cost of the disobedient party by some other person appointed by the court, and the act, when so done, has like effect as if done by the party. On application of the party entitled to performance, the clerk shall issue a writ of attachment, writ of assistance, or sequestration against the property of the disobedient party to compel obedience to the judgment. The court may also in proper cases adjudge the party in contempt and may award damages for disobedience of the order, if real or personal property is involved. The court, in lieu of directing a conveyance thereof, may enter a judgment divesting the title of any party and vesting it in others, and such judgment has the effect of both a judgment and of the conveyance executed in due form of law. When any order or judgment is for the delivery of possession, the party in whose favor it is entered is entitled to a writ of execution. Assistance or order directing the sheriff or other enforcement officer to deliver possession upon application to the clerk. Equitable decrees or orders to pay money shall be enforced as legal judgments to pay money unless otherwise ordered by the court. B. Recordation of judgment. A copy of the judgment directing acts or divesting or vesting title of a deed, or a copy thereof transferring title as provided in subdivision A of this rule or other law, may be recorded or filed either in the list pendens records or the deed records of the proper officer in county or place, and shall be appropriately indexed. When recorded or filed, such records shall constitute constructive notice thereof and transactions with respect to the property under the recording laws. And a copy of such filed or recorded judgment or deed certified by the county recorder or other officer shall constitute prima facie evidence of its validity. C. Deed form. A conveyance of land made by a court appointee as authorized by subdivision A of this rule may be made in the following form. A B. By the order for judgment of naming the court, in cause number, state the cause number entered on. State date order or judgment was entered. In the case of naming the party plaintiffs against naming the party defendants, conveys the describe the premises and the interest conveyed if the judgment or order is for less than a fee simple absolute, the title, interest and rights of name the parties or persons whose title is being conveyed, and the record owner through whom such title was derived if known, and if such persons are not record owners, state with warranty or subject to conditions only if and as provided in the order or judgment. Signed, signature of court appointee, a B, appointee of above-named court to make this conveyance. Acknowledgement as required in the case of deeds. D. Judicial sales. Property may be sold under judgments and orders in the manner now provided by law subject to these rules, including the sale of the property when a specific performance is allowed against the vendee. Rule 71. Process in behalf of and against persons not parties. When an order is made in favor of a person who is not a party to the action, he may enforce obedience to the order by the same process as if he were a party. And when obedience to an order may be lawfully enforced against a person who is not a party, he is liable to the same process for enforcing obedience to the order as if he were a party. Rule 72. Trial court and clerks. A trial courts always open. The trial courts shall be deemed always open for the purpose of filing any pleading or other proper paper, of issuing and returning process, and of making and directing all interlocutory motions, orders, and rules. Terms of court shall not be recognized. B. Trials and hearings, orders and chambers. All trials upon the merits shall be conducted in open court and so far as convenient in a regular courtroom in or outside the county seat. All other acts or proceedings may be done or conducted by a judge in chambers, without the attendance of the clerk or other court officials, and at any place either within or without the circuit. But no hearing other than one ex parte shall be conducted outside the state without the consent of all parties affected thereby. C. Clerk's office and orders by clerk. The clerk's office with the clerk or a deputy in attendance shall be open during business hours on all days except Saturdays, Sundays, and legal holidays. But the circuit court judge may provide by local rule or order that its clerk's office shall be open for specified hours on Saturdays or particular legal holidays other than New Year's Day, Washington's birthday, Memorial Day, Independence Day, Labor Day, Veterans Day, Thanksgiving Day, and Christmas Day. All motions and applications in the clerk's office for issuing process, including final process to enforce and execute judgments, and for other proceedings which do not require allowance or order of the court are grantable of course by the clerk. But the clerk's action may be suspended or altered or rescinded by the court upon cause shown. D. Notice of orders or judgments. Immediately upon the notation in the chronological case summary of a ruling upon a motion, an order or judgment, the clerk shall serve a copy of the entry in the manner provided for in Rule 5b upon each party who is not in default for failure to appear and shall make a record of such service. Such service is sufficient notice for all purposes for which notice of the entry is required by these rules, but any party may, in addition, serve a notice of such entry in the manner provided in Rule 5 for the service of papers. In cases of consolidated proceedings involving 10 or more parties, the trial judge may provide by order for alternative method of notice to designated liaison parties who undertake responsibility for forwarding notice to all parties. It shall be the duty of the attorneys, and parties not represented by an attorney, when entering their appearance in a case or when filing pleadings or papers therein, to have noted on the chronological case summary and on the pleadings or papers so filed, their mailing address, and an electronic mail address. Service at either address shall be deemed sufficient. E. Effect of lack of notice. Lack of notice, or the lack of the actual receipt of a copy of the entry from the clerk shall not affect the time within which to contest the ruling, order or judgment, or authorize the court to relieve a party of the failure to initiate proceedings to contest such ruling, order or judgment, except as provided in this section. When the service of a copy of the entry by the clerk is not evidenced by a note made by the clerk upon the chronological case summary, the court, upon application for a good cause shown, may grant an extension of any time limitation within which to contest such ruling, order or judgment to any party who was without actual knowledge, or who relied upon incorrect representations by court personnel. Such extension shall commence when the party first obtained actual knowledge and not exceed the original time limitation. Rule 73. Hearing of motions. AFN 1. Hearings upon motions. Unless local conditions make it impracticable, each judge shall establish regular times and places, at intervals sufficiently frequent for the prompt dispatch of business, at which motions requiring notice and hearing may be heard and disposed of. But the judge at any time or place and on such notice, if any, as he considers reasonable may make order for the advancement, conduct, and hearing of actions. To expedite its business, the court may direct the submission and determination of motions without oral hearing upon brief written statements of reasons in support and opposition, or direct or permit hearings by telephone conference call with all attorneys or other similar means of communication. FN 1. This rule contains no subbed. B. Rule 74. Recording machines. court reports, stenographic report or transcript as evidence. A recording machine's transcripts. For the purpose of facilitating and expediting the trial of causes and the appeals therefrom, the judge of each circuit, criminal, superior, probate and juvenile court of each and every county of this state may arrange and provide for the recording by electronic or mechanical device, or by stenographic reporting with computer-aided transcription capability of any and all oral evidence and testimony given in all causes and hearings, including both questions and answers, and all rulings of the judge in respect to the admission and rejection of evidence and objections thereto, and the recording of any other oral matters occurring during the hearing in any proceeding. The recording device or the computer-aided transcription equipment shall be selected and approved by the court and may be placed under the supervision and operation of the official court reporter or such other person as may be designated by the court. The court may, in its discretion, eliminate shorthand or stenographic reporting of any recorded matter. A transcript, typewritten or in longhand, made in part or entirely from such recording, shall serve the same purpose as if made from shorthand notes, and if certified, as in the case of a transcript of shorthand notes, shall serve the same purpose and be as valid as if made from shorthand notes. Provided further, that the judge may authorize or direct the court reporter or any other responsible, competent person, in his discretion, to make a transcription from such recordings, and the same shall be certified by the person making said transcriptions in the same manner and have the same effect as if made from shorthand notes. B. Reporter may serve as clerk and serve other judges. When the circuit court judge and the judge or judges affected find that such duties will and ought affect the efficiency of the court. 1. One person may serve both as a court reporter and clerk for a judge or judges whose regular courtroom is located outside the courthouse or its environs, and a court reporter may serve more than one judge. Appointment shall be made by the judge or judges affected and, if they cannot agree, by the circuit court judge. C. Pay and duties of court reporters. It shall be the duty of each court reporter, whenever required by the judge, to be promptly present in court, and take down in shorthand or by other means the oral evidence given in all causes, including both questions and answers, and to note all rulings of the judge in respect to the admission and rejection of evidence and the objections and exceptions thereto, and write out the instructions of the court in jury trials. The court reporter, when so directed, shall record the proceedings and make a transcript as provided in subdivision AOF this rule. Reporters shall be paid as provided by 1965 Indiana Acts, ch. 289 FN1, but the circuit court judge with the approval of the judge or judges affected may allow the reporter additional pay up to $125 per month for serving more than one judge or function, or serving as both clerk and reporter. D. Statutes applicable to reporters in preparation of transcripts. Except as provided otherwise by these rules, the provisions of 1899 Indiana Acts, ch. 169, paragraph 2-7, FN2 1939 Indiana Acts, ch. 11, paragraph 1, FN3 1935 Indiana Acts, ch. 218, paragraph 1, FN4 1893 Indiana Acts, ch. 33, paragraph 1, FN5 and 1947 Indiana Acts, ch. 89, paragraph 1, FN6. Relating to court reporters in preparation of transcripts, shall apply to court reporters provided by these rules. e. Stenographic report or transcript as evidence. Whenever the testimony of a witness at a trial or hearing which was stenographically reported is admissible on appeal or in evidence at a later trial, proceeding, or administrative hearing, it may be proved by the transcript thereof duly certified by the person who reported the testimony. Rule 75. Venue requirements. A venue. Any case may be venue, commenced and decided in any court in any county, except that upon the filing of a pleading or a motion to dismiss allowed by Rule 12b(3), the court, from allegations of the complaint or after hearing evidence thereon or considering affidavits or documentary evidence filed with the motion or in opposition to it, shall order the case transferred to a county or court selected by the party first properly filing such motion or pleading if the court determines that the county or court where the action was filed does not meet preferred venue requirements or is not authorized to decide the case, and that the court or county selected has preferred venue and is authorized to decide the case. Preferred venue lies in 1. The county where the greater percentage of individual defendants included in the complaint resides, or, if there is no such greater percentage, the place where any individual defendant so named resides, or 2. The county where the land or some part thereof is located or the chattels or some part thereof are regularly located or kept, if the complaint includes a claim for injuries thereto relating to such land or such chattels, including without limitation claims for recovery of possession or for injuries, to establish user control, to quiet title or determine any interest, to avoid or set aside conveyances, to foreclose liens, to partition and to assert any matters for which in rem relief is or would be proper, or 3. The county where the accident or collision occurred, if the complaint includes a claim for injuries relating to the operation of a motor vehicle or a vehicle on railroad, street or interurban tracks, or 4. The county where either the principal office of a defendant organization is located or the office or agency of a defendant organization or individual to which the claim relates or out of which the claim arose is located. If one or more such organizations or individuals are included as defendants in the complaint, or 5. The county where either one or more individual plaintiffs reside, the principal office of a governmental organization is located, or the office of a governmental organization to which the claim relates or out of which the claim arose is located, if one or more governmental organizations are included as defendants in the complaint, or 6. The county or court fixed by written stipulations signed by all the parties named in the complaint or their attorneys and filed with the court before ruling on the motion to dismiss, or 7. The county where the individual is held in custody or is restrained, if the complaint seeks relief with respect to such individual's custody or restraint upon his freedom, or 8. The county where a claim in the plaintiff's complaint may be commenced under any statute recognizing or creating a special or general remedy or proceeding, or 9. The county where all or some of the property is located or can be found if the case seeks only judgment in rem against the property of a defendant being served by publication, or 10. The county where either one or more individual plaintiffs reside, the principal office of any plaintiff organization or governmental organization is located, or the office of any such plaintiff organization or governmental organization to which the claim relates or out of which the claim arose is located. If the case is not subject to the requirements of subsections 1 through 9 of this subdivision, or if all the defendants are non-resident individuals or non-resident organizations without a principal office in the state, The pleading or motion permitted by this rule must be filed within the time prescribed for the party making it by Rules 6 and D12 and any other applicable provision of these rules. B. Claim or proceeding filed in improper court. 1. Whenever a claim or proceeding is filed which should properly have been filed in another court of this state, and proper objection is made, the court in which such action is filed shall not then dismiss the action, but as whole order the action transferred to the court in which it should have been filed. 2. The person filing the action shall, within 20 days, pay such costs as are chargeable upon a change of venue, and the papers and records shall be certified to the court of transfer in like manner as upon change of venue, and the action shall be deemed commenced as of the date of filing the action in the original court. 3. If the party filing the action does not pay the costs of transfer within 20 days of the order transferring venue, the original court shall dismiss the action without prejudice and shall order payment of reasonable attorney fees to the party making proper objection. C. Assessment of costs, traveling expenses, and attorney's fees in resisting venue. When the case is ordered transferred under the provisions of this rule or Rule 21b, the court shall order the parties or persons filing the complaint to pay the filing costs of refiling the case in the proper court and pay mileage expenses reasonably incurred by the parties and their attorneys in resisting the venue. And if it appears that the case was commenced in the wrong county by sham pleading, in bad faith or without COs, the court shall order payment of reasonable attorney's fees incurred by parties successfully resisting the venue. D. Other venue statutes superseded by this rule. Any provision of these rules and any special or general statute relating to venue, the place of trial or the authority of the court to hear the case shall be subject to this rule, and the provisions of any statute fixing more stringent rules thereon shall be ineffective. No statute or rule fixing the place of trial shall be deemed a requirement of jurisdiction. E. Appeal. An order transferring or refusing to transfer a case under this rule shall be an interlocutory order appealable pursuant to Appellate Rule 14a(8), provided, however, that the appeal of an interlocutory order under this rule shall not stay proceedings in the trial court unless the trial court or the Court of Appeals so orders. Rule 76. Change of venue. A. In civil actions where the venue may be changed from the county, such change of venue from the county may be had only upon the filing of a verified motion specifically stating the grounds therefor by the party requesting the change. The motion shall be granted only upon a showing that the county where suit is pending is a party, or that the party seeking the change will be unlikely to receive a fair trial on account of local prejudice or bias regarding a party or the claim or defense presented by a party. A party shall be entitled to only one change of venue from the county. Denial of a motion for change of venue from the county shall be reviewable only for an abuse of discretion. The rules of criminal procedure shall govern proceedings to enforce a statute defining an infraction. B. In civil actions, where a change may be taken from the judge, such change shall be granted upon the filing of an unverified application or motion without specifically stating the ground therefor by a party or his attorney. Provided, however, a party shall be entitled to only one change from the judge. After a final decree is entered in a dissolution of marriage case or paternity case, a party may take only one change of judge in connection with petitions to modify that decree, regardless of the number of times new petitions are filed. The rules of criminal procedure shall govern proceedings to enforce a statute defining an infraction. C. In any action except criminal, no change of judge or change of venue from the county shall be granted except within the time herein provided. Any such application for change of judge or change of venue shall be filed not later than 10 days after the issues are first closed on the merits, except 1. In those cases where no pleading or answer may be required to be filed by the defending party to close issues, or no responsive pleading is required under statute. Each party shall have 30 days from the date the case is placed and entered on the chronological case summary of the court as having been filed. 2. In those cases of claims in probate and receivership proceedings and remonstrances and similar matters, the parties thereto shall have 30 days from the date the case is placed and entered on the chronological case summary of the court as having been filed. 3. If the trial court or a court on appeal orders a new trial, or if a court on appeal otherwise remands a case such that a further hearing and receipt of evidence are required to reconsider all or some of the issues heard during the earlier trial, the parties thereto shall have 10 days from the date the order of the trial court is entered or the order of the court on appeal is certified. 4. In the event a change is granted from the judge or county within the prescribed period, as stated above, a request for a change of judge or county may be made by a party still entitled thereto within 10 days after the special judge has qualified or the moving party has knowledge the cause has reached the receiving county or there has been a failure to perfect the change. Provided, however, this subdivision 4 shall operate only to enlarge the time allowed for such request under such circumstances, and it shall not operate to reduce the period prescribed in subdivisions C, C1, C2, C3. 5. Where a party has appeared at or received advance notice of a hearing prior to the expiration of the date within which a party may ask for a change of judge or county, and also where at said hearing a trial date is set which setting is promptly entered on the chronological case summary, a party shall be deemed to have waived a request for change of judge or county unless within 3 days of the oral setting the party files a written objection to the trial setting and a written motion for change of judge or county. 6. If the moving party first obtains knowledge of the grounds for change of venue from the county or judge after the time above limited, he may file said application, which must be verified personally by the party himself, specifically alleging when the cause was first discovered, how discovered, the facts showing the grounds for a change, and why such cause could not have been discovered before by the exercise of due diligence. Any opposing party shall have the right to file counter-affidavits on such issue within 10 days, and the ruling of the court may be reviewed only for abuse of discretion. D. Whenever a change of venue from the county is granted, the parties may, within 3 days from the granting of the motion or affidavit for the change of venue, agree in open court upon the county to which venue shall be changed, and the court shall transfer such action to such county. In the absence of such agreement, the court shall, within 2 days thereafter, submit to the parties a written list of all counties adjoining the county from which the venue is changed, and the parties within 7 days from the date the clerk mails the list to the parties or within such time, not to exceed 14 days from that date, as the court shall fix, shall each alternately strike off the names of such counties. The party first filing such motion shall strike first, and the action shall be as and to the county remaining not stricken under such procedure. If a party is brought into the action as provided in Trial Rule 14, and that party thereafter files a motion for change of venue which is granted, that party and the plaintiff shall be the parties entitled to strike. A moving party that fails to strike within said time shall not be entitled to a change of venue, and the court shall resume jurisdiction of the cause. If a non-moving party fails to strike within the time limit, the clerk shall strike for such party. Rule 77. Court Records. A. Required records. The clerk of the circuit court shall maintain the records for all circuit, superior, and probate courts in the county. 1. The clerk of the circuit court shall maintain any record required by an act of the General Assembly or a duly promulgated rule of any state agency, including the following: A. Lis Pendens Record IC 32-30-11-1. B. Record of transcripts and foreign judgments IC 33-32-3-2. D. C. Judgment Docket IC 33-32-3-2, wherein all orders requiring entry in the judgment docket shall include the term judgment in the title and shall set forth the specific dollar amount of the judgment in the body of the order. D. Execution Docket IC 33-32-3-5. E. Records specified under the probate code. And F. Records specified by the State Board of Accounts as to the fiscal matters relating to the court and clerk. 2. The clerk of the circuit court shall also maintain the following records as specified under this rule: A. Chronological Case Summary (CCS). B. Case File. C. Record of Judgments and Orders (Rego or Order Book). And D. Indexes. 3. Records may be maintained in the following formats: A. Paper. B. Microfilm, provided the record is authorized to be microfilmed by the provisions of Administrative Rule 7B. Or C. Electronic, which means the record is readable through the use of an electronic device regardless of the manner in which it was created. B. Chronological Case Summary (CCS). For each case, the clerk of the circuit court shall maintain a sequential record of the judicial events in such proceeding. The record shall include the title of the proceeding, the assigned case number, the names, addresses including electronic mail address, telephone, and facsimile numbers of all attorneys involved in the proceeding, or the fact that a party appears pro se with address, including electronic mail address, telephone, and facsimile number of the party so appearing, and the assessment of fees and charges, public receivables. The judge of the case shall cause CCS entries to be made of all judicial events. Notation of judicial events in the CCS shall be made promptly, and shall set forth the date of the event and briefly define any documents, orders, rulings, or judgments filed or entered in the case. The date of every notation in the CCS should be the date the notation is made, regardless of the date the judicial event occurred. The CCS shall also note the entry of orders, rulings and judgments in the record of judgments and orders, the notation of judgments in the judgment docket, and file status pending decided under Section G of this rule. The CCS may be kept in a paper format, or microfilm, or electronically. The CCS is an official record of the trial court and shall be maintained apart from other records of the court and organized by case number, if maintained in a paper or microfilmed format. C. Case File. In each case assigned a case number, the clerk of the circuit court shall maintain a file in a single format. Unless it is necessary to maintain a case file in a combination of formats to accommodate a filing that cannot be maintained in a single format. The clerk shall make an entry on the CCS if it is necessary to maintain a single case file in a combination of formats. All case files, whether paper or electronic, shall contain a copy of any order, entry, or judgment in the case placed in the RJO, if the clerk is required to maintain a RJO, and the original or electronic copy of all other documents relating to the case, including pleadings, motions, service of process, return of service, verdicts, executions, returns on executions and, if prepared, certified, and approved, the transcript of the testimony. The RJO shall contain the original order, entry, or judgment, and the case file shall contain a copy of such original. Unless necessary to detail the filing chronology, the case file need not include transmittal letters, instructions, envelopes, or other extrinsic materials unrelated to the issues of the case. The case file, if maintained in a paper format, shall contain an index tab listing the case number and an abbreviated designation of the parties, and shall note the information required under Section G of this rule. In the event the court does not maintain a separate evidence file, documents entered into evidence, including depositions, shall be placed in the case file. D. Record of judgments and orders, RJO or order book. 1. Unless the court has a scanning system approved under Administrative Rule 6 that directly scans or electronically files documents into the court case management system and saves a digital image of a document as part of the electronic case file, the following provisions apply. The clerk of the circuit court shall maintain a daily, verbatim, compilation of all judgments of the court, designated orders of the court, orders and opinions of an appellate tribunal relating to a case heard by the court, local court rules under Trial Rule 81, certification of the election of the regular judge of the court, any order appointing a special judge, judge pro tempore, or temporary judge, the oath and acceptance of any judge serving in the court, any order appointing a special prosecutor, and the oath and acceptance of a special prosecutor. The clerk may maintain a separate RJO as required for the functional management of the court's business. Except where the RJO is maintained electronically, the clerk shall maintain a separate RJO for confidential materials. 2. If the court has a scanning system approved under Administrative Rule 6 that directly scans or electronically files documents into the court case management system and saves a digital image of a document as part of the electronic case file, the clerk need not maintain a separate RJO. E. Indexes. In addition to any index required under the provisions of this rule, state statute, or duly promulgated rule of a state agency, the clerk of the circuit court shall prepare and maintain indexes of all actions and proceedings in the circuit. Superior and probate courts in the county shall be in an alphabetical format which notes the names of all parties, the date on which a party became part of the proceeding, and the case number of the proceeding. In the event courts are not located in the county courthouse, the clerk shall supervise the appropriate preparation of indexes for these courts and provide for the combination of indexes for all circuit, superior, and probate courts in the county. If the court has a case management system that is searchable by party name, date, and case number, or has the ability to produce an index upon demand, the clerk is not required to prepare and maintain the indexes required by this rule. F. Pleadings and papers, where filed and entered. All pleadings and papers shall be filed in accordance with Trial Rule 5 with the clerk of the circuit court. In the event a court is not located in the same facility as the clerk of the circuit court, all pleadings and papers shall be filed with the clerk serving that court. If an initial pleading or complaint is assigned to a court not within the facility where the initial pleading or complaint was filed, The clerk shall promptly notify the person filing the pleading and transmit the documents to the clerk serving the court where the matter will be considered, and all further papers will be filed with the latter court. In the event an initial pleading or complaint is filed with the clerk of the wrong court, the clerk, upon notice to the person filing the initial pleading or complaint, may transfer the case to the proper court before service of summons or appearance of other parties, or any opposing party may move for transfer as provided for under Trial Rule 12b or Trial Rule 75. G. Case file status. 1. The clerk of the circuit court shall maintain the case files, as set forth under Section C of this rule, in either a pending or decided status. Pending files, arranged by assigned case number, consist of all cases which have not been decided. Decided files consist of the actions which have been concluded and no further proceedings remain to be conducted as evidenced by the final judgment or other order of the court. 2. When a case has been decided, the file shall be assigned a disposition date pursuant to Administrative Rule 7 of the Indiana Supreme Court and maintained under the original case number in a location apart from pending files. In the event a decided case is redocketed for consideration by the court, the disposition date shall be deleted from the file and the case file returned to the pending cases in sequence with the case number originally assigned. A disposition date shall be reassigned at the time the case returns to a decided status. H. Statistics. The clerk of the circuit court shall establish procedures to determine a statistical count of all actions filed, decided, and reinstated as required by the Indiana Office of Judicial Administration, IOJA. I. Replacing lost papers. If an original pleading or paper filed with the clerk of the circuit court cannot be located within the record-keeping system set forth under this rule, the court may authorize a copy of such record to be filed and used as the original. J. Method of record-keeping. Under the direction of the Supreme Court of Indiana,